Hi guys, it's Bill. Wait, Kathy. It's Kathy. Hope you're doing well. Sorry I overslept. Thank goodness Fozzie woke me up. I have an alarm set for 1:30, and that went off today and I jumped out of bed and I'm like, "Oh no, I'm late. I'm late. I'm late." And then I saw what time it is. I'm like, "Oh, I'm good. I have way plenty of time." So, I went back to bed. And that's why I'm late. But it happens. It happens a lot for me, I guess. Micah's birthday's over, so we don't have to talk about it anymore, right? Oh, the cat just jumped up and knocked my red care off. I'm not allowed to say the F word at the beginning of a video because YouTube does not like it, but okay, Nan. All right, I'm gonna try to fix my camera while we play a video.
We were discussing.
Okay.
I will update the court as to what we were discussing, and obviously, if Ms. Hurd, wants to join in or disagrees with how I'm characterizing. So
Okay.
you had asked about calling Mario's fiance Carrie to the stand,
Right.
Ms. Anderson to the stand. Obviously, I asked the defendant, did she want to do that? She indicated she wasn't really prepared to do that. She had some technological issues that she felt were preventing her to do that.
Okay.
I said, okay. Well, the judge seemed to indicate he wanted to get something done. I said, well, we have this hour. I thought, look, the judge is very clear on the drug testing being negative for Mario or negative for you, depending
Sure.
on what, if we have an hour and we're not ready to go with Ms. Anderson, why don't we put that to bed? And I put that, I also put to the question to her of bringing up our resolution generally. Want to go back to day one and talk about resolution generally? We had a little bit of conversation about that, didn't go a whole lot of places.
Now, do against that backdrop, and then of course fill me in as to the rest, but do the parties understand that sometimes they're concerned about settlement because the stakes are high? The parties could agree not to make any final custody label or designation at this time, but agree to a schedule, and then by the status check, see if that schedule's working, maybe agree to expand it and worry about labels then. Or if it all falls apart and goes south, then a person could renew their request to complete the trial and have rulings on the custodial designation. So that's available.
We didn't get
Okay.
anywhere that didn't seem like, so, that's kind of where we are, is I'm kind of saying, well, look, we've got 45 minutes. She doesn't want to move forward with Ms. Anderson, which I understand,
Okay.
I've been there. So if we have the time, do we want to go take a drug test across the street, get it out of the way, and it either, goes, and we put it to bed, right?
We wouldn't necessarily have the result now, but.
No, we have it, and then you'd have it by the time we came back, and if it's negative, and, my client will absolutely say, look, I thought I saw things, and I apologize, and your honor will do with that what you will. And if it's positive, at the end of the day, we're still gonna work with the defendant, and we understand that drugs are not a death knell to parenting, they're merely a safety issue in that moment, and we can always work towards, Ms. Hurd doesn't know me, but I have a lot of personal experience with that stuff. They're not a death knell to parenting. It's something that we work
And
on.
sometimes people do clean up and
Of
fall
course,
off the wagon,
of course.
just isolated before trial because of the stress.
It's
So
part,
there's
it's
also.
part of life, absolutely. So that's all I had said. That's where we left off, Judge. She had said she, I think, wanted to get some legal advice on, I
Well,
guess.
I'll ask about the other issue too, that you're,
Okay.
both issues.
Okay.
If we don't have an agreement on drug testing, we can put that off for the
That issue,
next
but
time.
the other issue about the, and stuff.
I'm
So
sorry?
I wanted to address
Go
both
ahead.
issues and
Okay.
at least confer,
With me?
no, no,
Okay, with your people?
yes.
Okay.
Well, not them. So,
With someone
like,
else.
someone who's in the
Okay,
law field,
So,
like
so I
that,
think
yeah.
here's what she's saying, Judge.
Okay.
It's almost 4:20. I certainly have, I could do another 25, 30 minutes or some stuff I need to go through with Mario, but you're gonna still need, Ms. Hurd's gonna wanna do some cross. It sounds to me like that's gonna be about 10 minutes. My suggestion is, it sounds like she wants, what I think she's saying is wants to confer with some legal advisors regarding the
Yeah.
terms of settlement we were discussing.
Yes.
She doesn't have them here
Oh,
to
so you
do-
did have the framework
We
or
did, we did.
something.
She doesn't have them here to do that with, so what I would maybe propose, although I hate to waste the 40 minutes, again, we would renew and say, I think there's still 40 minutes to go get a drug test, it knocks the issue out of the way, I understand, it sounds like the defendant does not want to agree to that, is that correct?
That's not it.
Okay, we'll circle back to it.
Okay, so, my sense would be, we've already truncated Mario a bunch, we did a nice chunk today, maybe we just adjourn and let her confer with her people, and then you can give us a date. Now, I'm hoping maybe before that date, we have an answer on settlement, so we don't show up surprised.
It's always a little difficult, because I always want people unrepresented, if they don't have a lawyer, to at least consult with one. On the other hand, if you have a case that has a really voluminous tortured history, and you give someone just a brief overview, the Reader's Digest version, which might not be sufficient, the opinion or feedback you're gonna get is not too helpful. If someone said, I'll read every scrap ever, of documents ever filed in this case, I'll watch the video of every hearing, that could be a very worthwhile opinion. But this is a case that is so far down the road that going into a lawyer's office and saying, should I agree to this label on this timeshare, with just maybe giving someone the overview of the case from her perspective, a brief overview, it's may not be helpful. I always want people to get legal advice, but whether or not she should accept a deal on a case with the files this thick and there's been a multitude of hearings, it's hard to render such a useful opinion. I'm sure you have this experience. You've had people you rendered opinions on where the case might have just been through one or two initial hearings and you read an original motion or opposition or whatever, but in something like this, you probably would say, hey, I can make some preliminary observations, but I don't feel comfortable offering an opinion unless you want to engage me to take a deep dive on everything. You know,
100% agree.
yeah. So how useful it's gonna be, I don't know, but on the other hand, I always want people to get legal advice. So, so you're interested in obtaining some legal advice on whether to consider certain terms that were proposed. Okay, very good. What else do we have?
I mean, that would be it, Judge, so it's 4/21. Certainly, I know we're gonna need to select another date anyway. Maybe we do that, and then I'll leave it to your honor whether you decide to, you know, adjourn a little earlier or have me ask Mario some more questions after that, I suppose, whatever your preference is, Judge.
Okay, I don't wanna have too much delay, but we had just had a couple that just came open. I have a settlement conference on Wednesday, the 31st, but it's at 10. If it doesn't settle by the noon hour, I could pick back up on this case at 1:30, or the next Wednesday, the 7th, it came open, either at 9 or at 1:30 or both.
The 31st does not work for me, Judge, but the 7th does. And I
The
can
morning
do either.
or the
I
morning
can do
or
either,
the
I can do either
afternoon.
or both.
Okay, which, is there any,
Yeah, what is that?
That's a Wednesday.
yeah, the 7th
It's a
Wednesday is, by the way, was this designated as day, this is session 2, okay?
You did this as session 3 and 4, Judge.
Oh, that's right,
You
this
did
is,
half day,
oh,
half
yeah,
day,
yeah,
and
that's
then
right,
you
let's
did
see.
D&D should be-
So, well, are we gonna need both on the 7th, the 9 to 12, or also to be safe, 1:30 to 5 as well?
I would say to be safe, do it, Judge. What I have is I'll finish up with Mr. Opari. Obviously, she'll do her cross. I don't know who else she intends to call other than Carrie, and then I obviously intend to cross-examine her, or the defendant rather, not her, sorry, I don't mean to refer to you that way. Ms. Hurd.
Ma'am's even more offensive.
Sorry.
Yeah, 'cause
You know,
she is.
I intend to cross-examine her, with the exception of some, you know, whatever you'd like to call what I'll do with Ms. Anderson, continuing with Mr. Opari and Ms. Hurd, that's all I have. So, you know, but I think to be
Okay,
safe.
so is 2/7 okay? Okay, so let's have that entered at this point, please, and not just at 9, but at 1:30 for the 7th. It'll be, the 9 will be session 5 and then a separate entry, because then if it just runs the whole day and it's not re-established in the afternoon, I'll assume the afternoon is available to give away. So to make sure that doesn't happen, then can you enter session 5, 2/7/24 at 9, and then session 6, 2/7/24 at 1:30, please? Okay, let's go ahead and take care of that. Are we able to handle that now, or? Okay, perfect, I appreciate it. Yeah, the 1:30, so it's not gonna be listed as 9 o'clock and then parentheses where it says all day, it's gonna be a separate setting for session 5 at 9 and session 6 at 1:30. So that, otherwise, we might have to give an order the afternoon.
Can we do this, maybe this might be helpful, Judge, because because I do know my client's gonna miss another day of work to be here, and it's important, so he will, obviously, Judge, but maybe just because originally we thought we had 2 days, the defendant has a myriad of witnesses, some 40 on her list. If we can just, I told you what I intend to do, if I can just
Yep.
understand from the defendant,
I'm-
what she, so what she plans to do, so that
Of
we can
those
prepare
other
and try and
witnesses?
make sure we're done that day.
Yeah, and we had
Yeah.
that dialogue earlier,
I
more to the
what you're
point,
saying.
what, as to the testimony of plaintiff and respondent, but these collateral individuals,
No, they're, no.
aside from whether Kerry's gonna testify, which we'll circle back to,
Right. I-
is there any of
That's
these other
fine.
people gonna offer
No.
testimony? Okay.
Okay, then I'm optimistic we'll
Is
be able.
Kerry gonna or do we need Kerry to offer testimony, or?
I don't think I need her for what I'm doing. I think the defendant has indicated that she wants to call her.
Okay, if you think you might, but you wanna sort of prepare it.
Yes, yeah.
Then we'll direct her to appear on the 7th.
Okay.
And we'll take her first, so she doesn't have to spend another whole day in the hallway, we don't.
Can I ask just this one accommodation, if we're gonna do that, Ms. Hurd, can you just let us know, let's say 24 hours before that start, if you intend to call her so that she knows to be here and ready to testify straight away, and that way, if you're not gonna call her, she doesn't necessarily need to be here at 9 AM.
Confirm.
If you can, just send me an email so that I know just on the 6th, let's say by 5
We have to soon because there's only 2 more days of this for us.
PM on the 6th, is that okay? Okay.
I mean, I don't necessarily, I mean, if I reflect or prepare on some of this, I may feel otherwise. I don't necessarily see that as critical testimony, but on the other hand, since the parties are discussing incidents where she was involved and there may, plus she's one of the caregivers, there may be some relevance to it, so.
And Your Honor, if I may approach Madam Clerk, just
Sure.
because you did admit these as
That's correct.
certified records, I have the formal certified so that they can make their way into the court record
Thank you.
for you. That was, if I recall correctly, that was our exhibit 49. Okay, and that way you have that there for you. That is our only copy, but you have it.
Right,
So-
but it'll always be available.
I know, I just wanted to make
If
sure.
you need it again, it's always available.
That is the risk. Okay, wonderful. We have our date. Then Judge, I'd leave it to you. You can recess at
Is
this
it,
point,
did you, it's either, if you wanted to complete a certain arc of, or thematic arc of questions with them, that's fine.
So
If you wanna
we
bring-
sort of did, and then you kind
Right.
of segued, and we, with the 3 things, and we broke. The next step I'll be doing is just basically medical care for the child, which is kind of a whole another step, and then I'll be done.
Sure.
So.
Do you prefer to pick that
I
up?
don't know that I'm gonna, I think it's gonna truncate if I don't. I don't know that I'm gonna finish it in 25 minutes.
Okay, so you prefer to recommence it on the 7th?
At this point, I think so.
Okay.
Judge.
Ms. Hurd, if you had any witness you wanted to, you don't want to call anyone else till the 7th. But I would say maybe we should deal with this, because Mr. Friedman had an opportunity to give us how his take or interpretation of the order, and you heard that from the appellate court, and you heard that. You can either make a statement on that now, or on the 7th, or during closing argument, or whenever else. You don't have to do it now. But if you do have any observations that you don't see it the same way as he described it in the certain aspects that you view differently, you can either explain that now, or you can save that till next time, or
No,
to close an
fine,
argument, or
save
till a
that.
closing brief, or
Yeah.
whenever. You can reflect on it, reread it, whatever.
I'd like to do that at that point.
Sure,
Okay,
absolutely.
thank you.
Thank you. Is there anything else for today's purpose?
I don't think so,
All
Judge.
right. Thanks. You guys just want to leave all your exhibit books here?
Yeah.
Right, we'll just put them all over here.
No, Judge, make them carry them with them.
Please. All right, we're on the record on Harry versus Hurd, D 622669. And everyone's present. Have appearances, please. Please, everyone have a seat, please, for the after appearances.
Morning, Your Honor. Cameron Brown, bar number 15876, filling in for Matt Friedman, who is counsel for plaintiff Mario Lipari, who is in the courtroom.
Please.
Kimberly Joy Hurd, self-represented defendant.
Okay, although it's a pretty aggressive calendar today, the court has a lot of commentary, and if the parties have a lot of commentary, we might have to set this for some different time next week. But a couple observations, and then I'm going to break down where I'm going with this. One observation is, and I don't know to what extent, because Mr. Friedman's not here, but some big picture analysis needs to be done here. It's not just a case-by-case basis. I'm sure your client understands by now, whether he should agree to this or not is a different thing, but unless he at some point agrees to 50-50 custody, this will not stop. Rightly or wrongly or in between, I don't know. Kimberly's going to litigate endlessly here or at the higher court or wherever, and for the next 10 years, till Aslan is 18, it will not stop. So he can either come to some sort of agreement, I don't know if a mediation referral would help, or he has to make a decision. He would rather finance your firm than Aslan's college education. And I remember a case from my practice years ago where I told my client, and the girl was about Aslan's age by now, 8 and a half, and I said, it's gotten to a point, I said, you can either finance me to endlessly represent you over the next 10 years, or you can send her to college. And I said, I think you should send your daughter to college. I think you should come to an agreement to share. This is not going to stop. And I just want to make sure that your firm didn't just look at this as an individual motions as they come. Oh, can we defeat or answer this motion? It doesn't matter. There's going to be 38,000 more. It's not going to stop until there's some sort of shared arrangement. That's my assessment. And now all focus has been lost because the motion, I said, okay, I can deal with this. It's sort of twofold. She's saying what's in the decree has to mirror what was stipulated on the record. If it doesn't, it needs to be corrected. Absolutely, it's absolutely correct. And the second matter was some incident of April 27th. Could that be a basis for a modification of what was agreed to? That's possible, but it's not. Since it's a subsequent event, it wouldn't be a basis to scuttle what was put on the record. So that's one observation that your client has to understand, and I think when our cards say attorney and counselor at law, I think there's an obligation, which I'm sure your firm discharged on this instance, to not just deal with this piecemeal, myopically, each individual case, but to look at the complex behavioral dynamics involved. And to
I think they're back because that was January and this is August. So I don't know what happened with the drug test.
realize it won't. I personally don't think it's going to stop until there's a shared arrangement of some sort. And if he's made the decision, I will bankrupt myself to avoid a 50-50 over the next 10 years. As long as that's an informed decision and he wants to litigate as much as she does, that's fine. The other matter is, which I'll come back to, which I think was in the supplement, the recusal. That's for obviously somewhat different reasons than Kimberly suggests. That's becoming far more viable for the court. The court thought it didn't make sense to start all over again with someone else. It's not a basic to recuse. If you say, oh, the judge did this, the judge did that. I'm still on a case where I think I'm the seventh judge, and the first six judges, as well as me, have been sued in federal and state court by the pro per litigants. So the others were getting off, say, oh, I'm being sued, I can't do this. I thought that just empowers someone to scream corruption, file a lawsuit, and automatically remove a judge. A judge is supposed to be only removed if there is an actual tenable conflict. But the fact is, I can't do this. I can't devote another 10 afternoons, spend more time than 20 or 30
No, Bobby.
cases, and then someone say, forget about all that, we're now going to do everything all over again. And there's this litigation approach, hyper litigation approach, maybe he plays a role in that. I don't know what happened on 4/27. Maybe he could have avoided conflict, because I think what happened here, maybe more so than a buyer's remorse or regret about the deal, that she originally proposed to negotiate. He probably could have done a better job isolating himself and his wife from some sort of conflict. I don't know what occurred. If you both want to say what happened on 4/27, that's fine. I think that's largely what this is about, along with some other things. But now
No, Bobby.
it's all over the place. If I remain on this, so the point of the story about me being the seventh judge on and not removing myself from the case when all the others were sued is it's not necessarily a situation which would hijack 8 or 10 afternoons of hearing every time that something happens. So the court had to stand firm on that. But this is a situation where I have to examine everything, the court's calendar, the parties, and it's certainly not in his best interest. I don't know if a new judge makes a difference or not. It's not in his best interest if every time you go through 10 days of this, that he pays handsomely for, it all starts all over again because somehow there's some conflict. He doesn't keep his wife away from her or whatever, and he doesn't have the ability to draw some clear
How'd your
line
wife?
where those two don't interact. And now, and now I just can't be spending all this circular, senseless time. I thought when she presented the motion, I said, I can deal with this.
We ought to do that. Do you want me to get that together? A members only. Name that tune. It has nothing to do with court. Or I could do the openings of the different court channels. Their songs, and we could try to guess them, but I don't know them all. Micah would know them all. Micah would win. Let's just do regular name that tune. I'll get it together. And then some Monday, we will do a members only name that tune. That'll be fun. Yeah, let's do this.
The decree has to mirror what was on the record, or if she has a basis based on the 427 incident to modify something,
Kelly, you were right.
fair game. Then we get this reply. Basically, everyone's conspiring against her. Everyone's corrupt. Mr. Friedman's not sending her the material. The court's conspiring for her not to get notice. It's an unhealthy environment to keep litigating the case under. She's obviously unaware that notices of matters are electronically transmitted by support staff, and the court has no involvement with that. There's probably no case in history, well, there might be,
Tomorrow.
I know, in some
It ends
cases,
tomorrow.
where a judge hunts down who's supposed to provide notice and say, I don't want him or her to get notice. And what good would it do? Because the party would just present themselves in court and say, I didn't receive
No,
notice.
Bobby.
And this court is fastidious about everyone has to get notice on everything. That's why, probably more than any other judge, I don't tend to sign much in the way of ex parte anything without notice to the other party, unless it's something innocuous like moving a court date up or something. But everyone has to get notice of everything of substance. I have no idea what's being referred to because I have no idea of any motion. These are her motions, so they would have been, once she put them into the system, they would have been electronically served on you, and there's no court involvement in any of that. So I don't even understand that argument. But of significant concern, I mean, if I make findings that someone doesn't like, I can get a grip on that. But if someone is saying you made findings when you didn't, I'm just going in circles on this. The reply says, you didn't make any substantive findings. Then it says, you did make findings, but they're incomplete and inadequate. Of course the court didn't make findings. The court would have made reams and reams of findings, but the parties stipulated. And now it's going so off the rails that the court knows or favors or conspires with his wife. I don't even remember as I'm sitting here that he had a wife, because there's so many cases and so much water under the bridge since that, which means now I would have to start over. I have a lot of notes, I have the video, but what good is it going to do for the court at great expense to everyone to start over with 10 whole new days and then just at the end of it, oh, it's no good, nothing to see here, everyone's corrupt. And he has to go, oh, it's an endless cycle. So maybe, just maybe, I mean, I can dream, can't I? But maybe, just maybe, a fresh approach, getting someone new assigned, because I will deal with as much aggravation as necessary and as much challenge as necessary, as long as people go through the proper channels and to either live with something or properly appeal it or bring emotion. But if everything is just so scattershot that unless I get everything I want, you're corrupt, and even if I get everything I want, you're corrupt, and that's the sense that I'm getting from this reply. If you have a litigant who really believes that, what good is it going to do? The court, it's difficult for the court to recuse and for it to be approved, but I'm determined to find a way to have this set aside, heard by someone else. If they try and return it to me, I'm not going to accept it back. I'm going to tell them they can take it up with Judge Weiss. If Judge Weiss insists that it be returned to this court, she can take whatever recourse she wants. But I can't keep devoting days and days and days to this, and someone wants to blow things open, and it's alleged this was wrongfully done or that's wrongfully done. What's really going on is the dynamics between the two of them. So, well, for starters, unless you feel this is just buyer's remorse, what happened on April 27th that it just keeps getting referred to as the center of this? What actually happened from each party's perspective? Because that might inform, I think that's a lot what it's about, or other instances surrounding it. Does it start with he can't keep his wife away from dealing with her, which he needs to?
Sir,
He needs to deal with this.
Just briefly, Judge, I know you kind of.
I don't have another 10 days and then, oh, let's do it all over.
No,
You're
I
all
understand.
wrong, you're corrupt. I can't keep doing it.
I told you I would
my
pay.
frustration is
Give
very
me more
palpable.
time,
It's a disservice
please.
to the parties to keep wasting their time and money with repeated do-overs, where if that's where we're going, where she stipulated or he stipulates, but then it's everyone else's fault that they came to a stipulation.
And just briefly,
Rather,
I know my client is.
I don't have enough. If I have 10 days to devote and it's going to end something, I will. But if it's just going to be used as more fodder to say this was wrong or that's wrong, I have to put a stop to it. I have to. And maybe, just maybe, this could be fooled. And I dread having to have some colleagues start from square one. But, and just so everyone knows, because there's a good chance that when something like this happens, and there's something with this momentous history.
It looks like they were doing a kid swap, and the wife did the kid swap, and everything went downhill. Ooh.
It's transferred to a colleague, and they can't get off. They might seek me out and say, can you give me the lay of the land here? I'm going to tell them I will absolutely not speak to you about this. I absolutely will not speak to anyone about this. I don't even, and I don't think it would be helpful. And someone would just say it poisons the well, and maybe it does. I don't think there would be any way to synopsize it in a way that would be fair to either party. So if something like that happened, which it can and it has, but over the years, and I've told people, I'm so sorry I can't speak to you about it. Just, I tell them, study the record, that's all I can do. But so that's where we're at. What happened on 4/27? Because that's a big part of all this. What happened?
Sure. And just briefly before I.
She says the police are reviewing it for prosecution or have.
And I think my client's willing to talk about it just briefly. I want to say, I agree with the court's perspective that this isn't going to end. I think defendant is just going to file.
Is
continue
it
to file
possible
motions.
if there's some new judge, a fresh approach, and there's not some inherent distrust by one or both parties from the start, that
I think the concern would be that this would then become a recurring cycle, that a new judge the defendant would ramp up litigation with the new judge, with the understanding that it's a new judge, new perspective, she has a second bite of the apple, per se, and that then the outcome would be the same because the facts are the same.
Okay,
the issues are
is the
same.
court wrong that a fifth that if we ever achieve a 50-50 arrangement, that might stop this, or then will it be, I want 60, 70, or 80?
I don't think Ms. Hurd will stop until she has primary or sole custody of the minor child.
Well, that could be, but I think the focus,
Okay, I just did a poll on should we move into another with the same judge, another shit show, just like we're watching right now, or should we go back to just clips? And it looks like we're going right into another shit show.
of everything she's said, filed, it seems to be, I have a right
I'm gonna
to share
ban
my
your
views
ass.
to some
I'm gonna
people.
ban you. I'm gonna
Keen
ban
to
you.
Go further, but at this point, unless I'm mistaken, I think that's where
Okay.
it's at. What is the percentage breakdown according to that stipulation?
I don't know, I'm not sure, I know it's primary, but
How does it break down percentage?
2 days a week.
2 overnights a week.
So like,
I think, what, 70-30 or?
72 to 28%,
Yeah.
okay. And what happened on 427?
And
Because I'm
we're trying to
sorry,
talk about it.
I'm gonna grant, I'm inclined to grant her request to recuse, because that way if someone wants to attack conduct by courts, attorneys, whatever, it's frozen in time as to everything up to now, and then you start fresh with someone else, and
And just,
if there's more activity that someone's concerned about, it's in another realm, you know, so.
in your honor, if that's the case, then I'd just like to make record that I think, recusal isn't absolutely necessary here. Like I said, I think that's going to
Not
cause
necessary.
the litigation to ramp up again with a new court or new judge. So just for the record, if that
It
is the
could,
case, then
it
I would
could,
hope
but-
that judge is, like you said, they'll review this record, you won't talk to them.
I didn't notice it until you said that, Glenda. It's a different lawyer. We're all on her because she can't keep a lawyer. He's got a different lawyer. No fade.
But I would hope that
I
judge
think they'll
is
try
able
and, they
with
may try and
attorneys.
return it. If I recuse, they'd try and return it, and I think I would, no, I know I would decline
I
that.
understand.
And if they wanna take it to the chief judge, which chances are they probably would not, but they might. We'd wait and see.
Okay. And then.
What happened on the 427?
Sir, excuse me, on the 27th, on a Saturday, Aslan had a Miracle League game. It was Miss Hurd's weekend to have Aslan, so my wife Carrie and I showed up there to watch the game. We were sitting at a table approximately from me to the bailiff from Kimberly, said hi to Aslan. Kimberly asked me if she could get a professional picture taken of me and Aslan by her friend Michael, which I do not like. Wait,
Look at that, just-
okay, I do not like.
Yes, I'd be delighted.
I,
What's so hard?
okay, sir, I said no, so,
Why?
because,
So most of the time, people don't follow up on this stuff. And
I don't know why she wanted,
Was
why she wanted a
Michael
professional
there at
picture
the
of
time?
me
Was
and my
Michael
daughter.
there at the time, or was it something for the future?
Anyways, there was a
Was he
disagreement.
there with his camera, looking to take photos, sign you up, and transmit a transaction? Or was it something, report to him or his studio at some time in the
I
future?
don't know.
Was he there?
Was he the photographer?
Yeah.
Yes. Her friend.
And you don't like him because,
Of all the nasty things he says about me on social media.
and there's probably gonna be a lot less of that if we think and say, okay, maybe I could, because you have a daughter to raise. You both do. You don't have,
No, Judge. No. I'm sorry. No. She asked him if Michael could take his picture, and he said no. That's perfectly fine. Dad did nothing wrong there. Nothing.
there's gonna be serious problems like this. You need serious people with serious solutions. And you're not serious about raising your daughter in a conflict-free environment if you get concerned about what people say on social media. Maybe I'm just thick-skinned for that, because once you're in office, there's so much of that stuff, so, but you just can't.
Okay.
Um,
So
So,
after that,
common sense, he would be saying a lot less or nothing negative about you if you just said, maybe I can nullify this. Let him take the photo, make some pleasant small talk about the game, and
So after that, sir, when I said no, there was some tension there, and then I decided that my wife and I were going to leave.
did you understand by saying no exponentially, this individual is gonna be, who you say aligns with her is gonna be more hostile to you, post more crud, as opposed to less. You can't indulge these quote-unquote principles stand on minutia issues where if you handle it a different way, you can reduce the tension. And when you reduce the tension, the beneficiary is your daughter. Do you understand that? It's not about you and being pissed off at this guy. It's about, by extension, the more I reduce conflict, the more my daughter benefits, right?
Yes, sir.
So try and think of it a little differently next time. That's all I'm asking you.
So there was some,
Okay.
there was some tension between us, so I decided me and my wife were going to leave, so there wouldn't be any more tension. I went over, gave my daughter a kiss goodbye. As we were walking through the concourse, out to the parking lot, Kimberly walked up right next to me and my wife and followed us out to the parking lot, leaving Aslan with Michael. And then continued, and then started to proceed to get into Carrie's face to try to get her to aggressively attack her, which I stood in between them with my back to
What was being
Kimberly.
said? What was being said?
There were a lot of arguments, sir. My wife had her phone and her coffee in her hand.
Okay.
And Kimberly ended up pushing her and dropping her phone on the
Did
ground
you,
and
did
the
you
coffee
try
on the
and
ground.
get between them and direct your wife? Just go over there.
Yes, I did. I tried.
Quiet.
And
Don't
Kimberly
engage.
kept insisting
Don't
on,
engage. What was the topic?
why did she follow us out to the parking lot, is why. She had no reason to follow us out to the parking lot. We were leaving. We were
Did
getting
you-
in the car and going
Did any,
home.
in all
So
this
we went
yelling
and filed
and
a police
screaming,
report.
did we determine what this was about? What was this all about?
Just because, I believe it started because we didn't want to take a picture with,
Oh,
for them.
okay, and
And we,
you
and the
reported,
parking lot
if
is
she
about,
reported it to the piece of paint, did you do that as well?
or my wife filed a police report that day.
Because of,
Kimberly assaulted her.
how did she, by pushing?
She pushed her and knocked her phone and her coffee out of her hand.
Okay. Let's assume for the sake of argument that that could technically constitute a possible assault if that happened. So, did you ask yourself, and I understand that if someone's actually injured, you gotta do something like that. Did you ask yourself, is this going to help is this gonna help the climate or the interactions, or is it gonna make it worse? Because that's what I think this is really about. That's why I'm asking.
Yes, it's the
I
husband's
don't think
fault
this is
here.
about
Yep.
Suddenly, she believes Mr. Friedman and the court are conspiring not to send notice. I think it's about this and some other conflict between you all. Did you consult your lawyers on this before
Judge, I
reporting?
think given the actions of defendant and the allegations throughout this case and kind of the absurd allegations that have been thrown out, we have advised our client to document everything
The
because.
document is fair enough, is a bit different than the,
Well, I mean.
because so
otherwise
you would
it'd be in a
agree
situation
that by
where it's he said,
reporting
she
her,
said.
it's increased conflict,
I would
it's
argue that
increased your
she-
attorney fees.
I would argue that her shoving my client's life increased.
Thank you. The lawyer finally said it. Him reporting the problem isn't the problem. Her creating the problem is the problem.
Maybe, yeah, well, but if you take these principled stands, I'm in the right even if you are, and you don't see the big picture, where you let nothing, he's right, you have to document everything, because so what if she runs off and files on him first, I get it. But if you don't see, how is this gonna play out? Is it that critical that I need to make this principle stand? What effect is it gonna have on our daughter by increasing the conflict? What effect is it gonna have on my bank account by hiring lawyers to deal with this? These two are living in a world where they don't quite have the luxury that other people do, because every stupid, inane argument or conflict that they don't de-escalate is at least costing your side thousands of dollars, and her perhaps as well if she gets an attorney in the future or she misses time from work or to be at hearings or whatever. So, but if you guys can't take anything from what the court's saying, I'm just wasting my time, because if both sides, and I understand the one side's more committed maybe to legal conflict and violence, but your client's de-escalation or avoidance skills were de minimis here.
You
And if you
can't
say,
believe
what
that.
would have I'll tell you exactly what would have I done.
Your
And
Honor,
I've been in many situations.
I tried to leave.
And I would
Your
say, I would have said, whether I would have purchased the photo later or not, I don't know. But I said, yeah, sure, I would have posed with the, posed for, that's the end of it.
Certainly, but I think that ignores the emotional impact that 3 years of being bashed on.
But that's exactly correct, but unless you
Which is why he tried to leave.
compartmentalize and separate that out, that all becomes some big mishmash, then every conflict gets magnified and everyone takes a quote-unquote principled stand, and they don't notice that these little acts of cooperation have a shockingly profound effect. And try it next time and tell me if, for example, if this guy is still blasting you on the internet. I can promise you,
Okay.
virtually promise you, that if you had a 98% certain, can never be 100, had you had a pleasant exchange with him, let him snap his photograph, you would have gone on the internet and seen no new disparagement of you by him.
Sir, the problem
If
wasn't
you'd make
with him.
small talk about the game, or,
Yeah,
okay,
I
if you
understand your-
don't take anything from this, then you deserve to keep spending. You know what dynamic you're dealing with, and if you think that you don't have to create some de-escalation and avoidance skills, but you can just keep taking these quote-unquote principled stands that are just going to make everything tenfold worse.
Oh yeah,
I've tried.
I would have beat her ass.
and no one's interested, so that's that. Okay, so.
Understood, Your Honor, and if we could maybe just get back to the motion at bar.
Well,
because I think
kind
this isn't
of, the
before you.
motion, but that's the whole thing. I'm saying if we're myopic enough to just look at the motion at bar without understanding that if we don't deal with these other issues, this is going to be endless. It'll be all the way till she's 18. Is that point missed?
No, Your Honor.
Until
I-
either there's an agreement
We are
for
fully
a
aware
shared
of that.
arrangement, if everyone just says, oh, nothing, I'm gonna do what I'm gonna do, I'm gonna take my principled stand, I don't want any advice about how to avoid conflict and not bankrupt myself with all these endless motions, and I'm gonna continue to approach things this way and not listen to any advice, I don't know what to tell you. Because that your statement just gives the court all the more reason to recuse, because the court can find that its suggestions about how to de-escalate and avoid conflict and attorney fees and to take proportionate reactions to matters, that there's no interest in it, and the laser focus is just simply on the motion before us. Okay, what happened on April 27th?
Well, I disagree with what you said.
About
there
what?
was a-
About what?
About me attacking his wife, I didn't.
Did I say you attacked his wife?
No, I didn't.
Oh,
What
I'm
you
sorry.
said,
Okay, I'm
Not
sorry.
you, sir.
Okay.
I never touched her, I never put hands
Start
on
at the
her.
beginning, what happened? Was it Mike and the camera, or
Yeah,
just tell the
it was
story from the
It's
beginning?
my best friend Mike, he's a professional photographer. I thought it would be nice to get some professional photos. I offered as my gesture to create peace. He said no, made some snide remarks, and then it escalated from there. They did go to leave. I asked Mike, can you please watch Aslan so I can go talk to them, hoping that I could de-escalate the situation. Instead, it did not do that, so,
Liar,
Are you aware that Mike
liar.
disparages him on the internet?
I don't know what he's referring to because we're not even friends. He's not even friends with Mike and Mike. We're all blocked from
Are
each
you
other, so
friends with Mike?
I am, yeah.
Do you share with Mike information about this case or talk about Dad?
I don't directly know. What his observations are is just what his observations are. Is my
How's he
friend.
observing it? Do you have any connection to the
The
litigation?
defendant posts videos on YouTube of these hearings. Your Honor.
Oh,
They're public hearings, so
well,
yeah,
veterans in
I
politics
get
actually
that, but
post
that's
them,
not the
so
point. The
This case
point
is
it's not
is
sealed.
Mike inserting himself into this.
Anyways, bottom line is,
All right, if you don't
I
wanna
went to
answer,
talk
that's
to her,
fine.
she threw her
Okay.
cup at me. If you see, I have the lacerations across my chest, she broke my skin. She cut my chest. She's a foot taller than me. I'm not capable of, I'm a strong person, but I'm not that big. She's quite significantly bigger than me, and she's constantly used her size to intimidate me. I've brought this up to this court for the last 3 years. I am scared of her in her presence. I do not like being around her. I've asked Mr. Perry not to
What
have
is it
her
about, when have you ever, to this court, because this court would be not just delighted, but ecstatic, if you need to set these exchanges up in a way that she's nowhere near you.
I've asked for that. and she's not
There was
supposed to
no
be.
way the court would have said, no, I want you endangered. So tell me what the current situation is for the exchange and how it needs to be changed so that she's not there.
So it's done at Starbucks, and at that Starbucks, it was just supposed to be him, but then he starts sending.
And that's
his
the order,
wife.
right? See, that's the order. It's just you and him.
Yeah,
That was my
that's what
order.
it's supposed to be, but he starts sending his wife, and then she
Okay,
escalates the
so
situation.
it's
and I ask
untrue
him to
that the
stop.
court did not address this. You've been telling them for years. If you think there's a violation by them, that's different than the court. You make it sound like the court told her, issued an order that she's to go there. So we agree she's not to be there.
Okay. That's what I've asked.
Okay, now, you're saying that Mike has no knowledge of any of this, even though Dad said he could easily prove that Mike posts all this crud, and that Mike posts videos of the hearing?
No,
Sounds like
Mike
he's
doesn't,
pretty
no.
deeply engaged.
No, Mike, he doesn't post any videos. I don't know.
Does he
I don't
comment
know
on
what-
them?
On my videos, they're on YouTube. None of my friends or
Let me
family.
put it this way, how
comment on
close
them.
are you to Mike? Do you confide in him?
He's one of my good friends, but the only thing the only person I really confide in is my mom, right
Do you
here.
know
Other
why-
than that, I
do you
don't
know-
confide in anybody.
Do you
This
know
is
why,
kind of
okay,
embarrassing.
do you know why Mike would be, if that's all true, do you know why Mike would have an emotional investment and
He
be
didn't,
close
and
to
that's
him?
why he showed up that day, and that's why I said, Mike, do you mind if I offered to take a picture? He goes,
But
"Absolutely."
what I'm wondering about, I'm assuming, if you're saying he can't prove it, fair enough. But if he was able to prove to the court that there's these negative postings about him, you would have no idea how Mike got the perspective to attack him on this.
He's my friend, he knows, he knows
So he
the
knows.
situation, not the details of it, he knows that I'm.
Have you asked
struggling-
him not to post?
I don't know what you're referencing though.
I don't know.
what
I
post.
don't
don't
know.
know either, I don't know either, so I don't know what to tell him not to do, cause I don't know what he's referring to, he's never
Okay,
showed me, I
when you
don't
told
know.
him go over there with the camera, what'd you tell him?
I'm sorry?
What'd you tell him when you told him to go with the camera?
Well, I didn't tell him to go over there, I just asked him, cause he was there to take pictures, I go, hey, would you mind taking professional pictures? He goes, yeah, sure. And so I asked Mario, would you like my professional picture of you and Aslan, and that's it, that's all I asked, and then
What did he say?
he said no, because he doesn't like Mike, that was the first time he's ever met Mike, he'd never met Mike before that day, so I didn't, his feelings towards Mike came kind of out of left field, because he's never met him before, so I didn't know.
If he's never met him and yet he's posting all this stuff about someone he doesn't know, angry, disparaging stuff, and Mike is your friend, it means that Mike is taking up for you and information, a lot of information's been shared with him.
Him, I don't understand that doesn't certainly warrant the situation.
But if you weren't confiding in him about all of this, and he otherwise knows little or nothing about it, would it make sense that he would attack a stranger on the internet?
No,
Okay.
yeah, I agree with that.
Right.
And I am trying to move forward, I'm not saying I've been perfect in the past, I'm just trying to move forward, and that was my act of trying to
So,
move forward.
if there's a problem with what happened on 4/27, or if the decree isn't reflecting what occurred on court with the stipulation, which is fine, and that you kept focused on the motion, then what's this reply that, there's all this conspiracy going, because I can't really address that all. If you think there's corruption and conspiracies, you can report it to the proper agencies and probably should, but what can the court do with something like that? Nothing. So if that's the way this thing's devolved, then I probably agree with you that I don't want to waste a lot of your guys' time and resources listening to days and days, issuing orders that get immediately attacked and challenged with assertions of conflict, incompetence, conspiracies, all this. It doesn't serve anybody. Now, to your point, is there going to be any difference if it's with someone new? I get it, maybe not, but I don't know what else to try. I just can't keep devoting for the next month half my court time to a case where someone says, we're not interested in how you ruled, or we settled it ourselves, but now we're going to pound on the court for not making rulings or findings, which of course, did you realize when you said in your reply, when you said I made no findings, or that findings I made were incomplete, do you realize, of course I didn't make any findings, because you guys stipulated to. What is, so, aside from this incident, is there something about the timeshare that's wrong between what he wrote in the motion, in his order, and what was stipulated to? What was
I feel like the
incorrect?
stipulation was done under duress. I was coerced into
The
that
rest, you
stipulation.
you were the one that suggested that you wanted to speak to Mr. Friedman.
I spoke to them because I wasn't getting any time with my daughter, and this court made
Okay.
its decision very
Okay.
clear before all the facts
Actually,
and evidence
actually,
were
the fact
presented.
is, that's a tough sell when I'm listening to 9 or 10 or 12 dates of hearings, and you don't have any rulings from those hearings that you can point to establish that. That's a tough sell. But why did you, when you reached,
Cloud, we were just talking about you. You got a gift membership yesterday, and we missed you a lot. Thank you for stopping by, Cloud. Guys, Cloud is here. Hi, Cloud.
out, what were you attempting to establish, and what percentage or time are you looking for now? Let's start being practical. I don't think a bunch of endless accusations and name calling solve the problem of what type of schedule are you interested in?
I'm interested in a schedule where I get to parent my daughter and not.
What would that look like,
That, well,
percentage time-wise?
right now, she's taken to school and picked up to school by a third party, 5 days
Okay.
a week. I wanna do that. On
Okay.
Monday, she's taken to therapy by, a third party. I wanna do that. She doesn't need to be taken and watched
Okay.
by a third party when I'm
Okay,
available.
so rather than all of this blowing everything open at the cost of tens of thousands of dollars, why don't you just, because I'm gonna see if there is a way to recuse, because it's just not getting anywhere.
What is a Zimmer
And
frame?
I
Zimmer
can't keep
frame.
spending all this time and then repeatedly do it over and over and over. And then no matter how many times I do it over, there's all these accusations, so can't there at least, until you guys figure this out on a broader basis, and she has her weekends, can't there be an agreement if he's unavailable to pick up from school or pick up to take to either therapy or medication, physician, pediatrician, whatever the case, that according to the statute, that a natural parent would have first dibs over a third party. And I understand that we probably need a much higher cooperation level and communication level between the parties to make that work effectively, but the statute does mandate it, so.
And that's all I'm asking for.
So what,
Thank you, Your Honor.
And I don't think my client's.
And I'd be tempted to send them to mediation to see if they could, but I think there's too much credit in the way.
Your Honor, we just had 5 long days of trial. We were here on a limited
seemed
remand
more.
to add additional findings, and then Ms. Hurd stipulated to the terms. She was canvassed in extreme detail. Both parties were. She agreed to those terms. And just as a brief correction, the
Okay,
order-
but and I think, again, we can't be myopic in a case like this and let's just deal with the motion.
I understand.
You have an obligation to your client to underscore that he either has to commit,
And we've
he's
discussed-
obviously has seen, you may not know, but he obviously knows what I'm talking about, because he's been living it, and his bank account reflects it, and his stress level reflects it. But that's what it's gonna be in store for the next 10 years.
I can't figure it out, Fozzie.
Solution is reached. Now, I understand your point that no matter what solution is reached, it seems to be a constant do-over. I don't, I mean, if I was gonna rule on what's here today, but if I'm gonna, I would probably indicate, unless someone can show that there's something in the stipulation that didn't make the decree, that probably sustain the matter, because I can't, it's a little difficult to accept a duress argument from someone who suggested a stipulation, but she doesn't understand and isn't expected to. Duress under the law is almost a gun to the head a situation, or you're being threatened, I'm gonna do this to your family, I'm gonna do this, these absolutely horrible criminal type things usually is what duress means in a legal sense. It almost can be virtually impossible in some instances. But it comes in cases where you take advantage of people of diminished capacity, someone who's 88 and has Alzheimer's, and you're the caregiver and you have them sign a bunch of documents, those type of situations. So it doesn't tend to fit situations like this. But if she's right, is she right though that because the only thing I can deal with of all of this that makes any sense, because we don't scuttle stipulations because of something that occurred subsequently. They report each other to the police, we see what happens. If that's a basis to modify a current agreement, we can deal with that. but it occurred subsequent. So the call of the question for today is, if you can establish that the decree was identical to what was agreed to, the court can deny the motion. If we can't establish that today, the court's gonna have to defer it and intends to recuse itself and find an appropriate ground or phraseology to do so. And we'll wait to see if that's,
And, Your Honor, I believe we put an exhibit in front of you that indicates that the court had already reviewed the decree when it was submitted, compared against the video record. My office reviewed it against the video record.
Sure.
It directly comports and mirrors those terms. that are
but
in the
it's
record.
but it's still possible that sometime if error is possible, if a clerk reviews something and correlates it with what was on the record or reflected in the minutes, and then only one side signed it and it's approved, then it goes to the next level and finally goes to the court for signature and it's signed. There's still cases where somewhere along the line, something broke down or wasn't inserted, and if so, there would need to be an amended decree.
I can't. You would all know first. First, I would talk about him for a while. Then I would make him come in here and be vetted first.
I don't think that's really what this is about. I think it's about, I want my child or half the time or more. I don't really think it's about, I'll be satisfied if those two things correlate. But dealing with it as the only valid immediate legal issue that the court can deal with via the motion.
Correct.
The court, that to the extent the limitations of the court's order is all these other collateral issues can be deferred to the new court, to the new judge,
Nan, thank you for letting me borrow your shirt.
if the recusal is permitted, which I assume it might be. I could be wrong about that. But that, to the extent that the decree does not correlate with what was placed on the record, it will be corrected. But, and that's the call of the question, it's not, it's not, well,
No, I'll take a
I
poll.
don't agree with it, all this other stuff, or it was unfair to begin with, or I'm under duress, or I can't deal with all that. Let's if I'm gonna recuse, it's unfair to deal with all that, but it's totally appropriate on just simply objective ministerial matter prior to the court recusing itself to determine if the decree reflects the agreement. And let some other court deal, the new judge deal with the set-aside issue. But, are you, and then we do kind of have to move on, are you, because I'm getting mixed, I need a direct answer to this. Not all this other stuff happened, or the whole thing was unfair from the start. I get it, it's been argued a million times. Dealing with what the court's able to deal with today, is the decree defective or incomplete as to some of the agreements that were put on the record that?
Yes, for
Which
example,
parts?
child support.
Pardon?
Child support,
What did it say?
it said $398 a month, and it based it on my revenue, not on my actual earnings.
Okay, but that was a determination you two made, right?
No, we didn't, it was, what should be $140 a month, Mr.
I don't think, I could be wrong, I don't think the court made that
You
decision.
didn't make
Okay.
any
Based
child
on-
support.
Right,
so-
It's based
so
on
who
gross income.
who decided that?
It's
Mr.
based on
Friedman.
her financial
So-
disclosure form.
Oh, so it wasn't stipulated at that time, but was decided later on?
We determined to base child support, I believe, based off of her gross income from her financial disclosure form.
It wasn't gross income, it was
Okay.
revenue.
Under
Okay, well
NAC
now we're getting
20.
somewhere. Number one, was there a second or third problem, or was that the main?
That was the main one, as far as it not following.
Right,
paperwork,
okay.
That's what you're saying. So
Okay,
that's- yeah.
what income did you base it on?
Her financial disclosure form, Your Honor.
Okay,
And
and
so,
the problem with that is,
They're basing it on my revenue, I'm an independent contractor, that's not my gross. Gross and revenue are two different
Okay.
numbers. Also, Mr. Perry does receive social security,
My
so I was
client's
asking
income
for
is
an
not
offset
relevant.
of that.
my
He
client's income is
receives
not
her
relevant.
SSI,
Pardon?
his financial
not
disclosure says he
particular,
receives
it's,
$940
until it gets
a
to
month.
be a joint physical custody situation.
Miguel, we need more information than that. We do.
The other side's income is generally not a huge factor. But what income should have the support been based on?
My gross income, and it would have been based on the calculations for low income would have been $140 a month. That would have been the correct amount.
Your Honor, I
Well, how
think-
much are you earning after you pay
My last,
overhead and such?
I haven't done my taxes, I'm still doing
Uh-huh.
those because it's pretty complicated, but my last financial disclosure form, I think, said just under 1,200 a month.
Or how do you survive?
That's why I am living with my parents,
See,
And I'm
well,
hoping
that's what I was
actually-
wondering about, okay,
yeah.
okay.
But Mr. Opa Perry receives her SSI of $940
When you
a
sent
month.
did you,
She lives with mom and dad, so she's a shut-in, guys. She's the one they were talking about, not us. They weren't talking about us. They were talking about her.
send an explanatory letter
Yes, I
about the
did.
breakdown,
Yep.
overhead and
pages.
expenses, or
Yep.
did?
No, Your Honor, we haven't received proof of expenses, I don't think we've seen
I
seen
thought
any
I
of
put
that,
that in
and
my-
then
yeah.
I think defendant is, misunderstanding how NAC 425 applies.
Well, I don't think you guys should have left it unresolved, because
Well,
I probably didn't focus on that. Had I focused on that and
Judge, I think-
had known or been conscious of the fact that she was gonna send information to you.
I don't nearly date, Cloud. What happens is I see that someone has something that I like, and then I ask them to marry me. That's all. That's all. Yep.
You guys, you were gonna calculate a number. I would have told you guys, that's a guaranteed dispute, which it turned out to be.
Judge, if you can, I mean, we sent the decree to Ms. Hurd on April 22nd, we received no response, we followed up.
Why
on
didn't you
April
tell them,
29th.
the numbers should be lower, and here's why?
I did, I sent them an 8-page letter,
We followed up on April 29th, we again
and I sent
received
an
no
email, I
response.
sent them.
Okay.
We followed up on May 3rd, we
Okay,
received no
let's
response.
say for the sake of argument, they'd agree to lower it today, and we get that in there. Is that gonna, are you still gonna pursue all this, or what?
Yeah, yeah.
Okay, well then, if you guys wanna stipulate on something, that's fabulous on an amount, if it's gonna slow things down, but if the litigation's still gonna, go on and on, but the court will say that if she is entitled to a motion to reduce, it would be retroactive to the day the stipulation was placed on the record, so if she's correct that the wrong numbers were
Judge, she
used
hasn't
or
paid
whatever.
any child support
Pardon?
since,
Well.
so.
And that's another thing, because I was gonna ask, it's kinda, and if a new judge gets it, I will give a piece of advice. Judges tend to get aggravated about support arguments where
Yes, I do.
if
Yes.
someone's
Absolutely.
arguing, like if you spend time, someone saying he should pay 800, he's saying, no, I should pay 463. And what the upshot of it is, and this happens a lot in child support court, the person doesn't intend and hasn't been paying anything, so it's sort of a phantom argument. Now, that being said, if you're gonna actually have some semblance of compliance, if a reasonable amount is arrived at, that's what you should, concentrate on. Maybe if you agree to an amount that's more commensurate with her.
Guys, what if Bill was the judge here? How many words would be in this total hearing if Bill was the judge here? I think Bill has a crowd going to Texas at the end of March, but I don't know what days. Yes, absolutely. Yeah, absolutely. Bill, what days is everybody going to Texas? I'll go. I'll stay a couple days. All right. All right. We're going to pick some days.
Income, maybe you'll get compliance. When you got that 8-page letter,
It was
do you
after
feel
this-
she didn't, prove some of this overhead or other expenses, or what?
Correct, Your Honor, and we received that after we had already submitted the decree to the court and after we had waited over a month for Ms. Hurd to send us.
When you saw it, did you send her something that says it looks like the calculation should be $398, and here's why?
I believe, I don't know if.
Did you receive
I'd have to ask
anything
Matt.
saying,
I
okay.
didn't.
But I know we based her income off of her P and L, which from July 1st to September 1st showed $7,472.23, which is $2,490.
Is your client of the belief, she's self-employed, there's nothing to attach or withhold? Is he of the belief that he's gonna receive something in the future if it's an amount they
I
agreed?
showed-
I don't know that in the
My
course of
deductions.
in case we.
If he believes that the future's gonna be similar to the past and he's never
would
gonna
assume.
receive anything, he may decide how much of a fight he wants to pick on this issue as well, I don't know.
Understood, Your Honor.
Okay, So for the purpose of today, the court, just basically all the upshot of all of this is, the court obviously made a lot of observations for the record, which are on the video record. If the parties want that in the order, that's fine, or if they just wanna keep the order clean as to the actual rulings, that's fine, cause all the other material's on the video record anyway. So, the court's simply ruling that if the, that defendant, reserves the right after reassignment to determine that the 398 support is too high according to her self-employed income and overhead and other deductions, and she reserves the right to argue before the new judge for a reduction. And secondly, that the court tends to recuse from the case. Probably we need to set a status check to determine whether the court's, just in case the court, that was denied and the court has to proceed. And if it is effectively reassigned, we can remove the status check. So can you give it 2 month? Probably you only need a month or so.
Just briefly, Your Honor, while we wait.
Wait, just, I'm sorry, just wait so I get a new date, otherwise I forget.
In a month, we have September the 30th at 11 a.m.
I think a month's all right to know whether, well, you know, actually, if a judge wants to send it back to this court and Judge Weiss gets involved, sometimes it takes, so just to be on the safe side, let's go 2 months.
Okay. That would be October the 24th at 11 a.m.
Because
11?
Yes.
Because a large percentage of what chief judges deal with is a multitude on a daily basis, disqualification motions. The large majority of them are filed by pro pers, but not all. Some are filed in cases where both parties have attorneys. So 10-24-25 status, Ray recusal slash recusal, comma, and any and other issues. The other issues would be, if the recusal doesn't occur, then the court has to start digging into these other issues. But as for today, the court's not ruling on the set aside directly, and that's deferred to the new judge if that occurs. But the court will rule that if she's correct, the 398 can be lowered and would be retroactive to the date it was set. But let the new judge receive the material and decide what's appropriate. And again, have a conversation with your client whether it's spending money for another empiric paper tiger victory, whereby if he honestly believes in his heart of hearts it's going to be like pulling teeth to ever get any support, why waste all his time and money? And I don't know how he feels. Maybe he feels, yeah, I really could use the help. But I would advise you to at least have this discussion with him, because there's an awful lot of tremendous, and I always say, why are we doing this? And I even see other judges doing it. I say, why are you getting so caught up in what an amount should be when someone hasn't paid anything?
He treated her exactly like normal during today's docket. I didn't notice anything with Victoria.
In 5 years, and that prospect seemed nebulous at best. Why are we doing this? I said, we'd have to walk away from it or agree to a figure that someone might actually start paying. I'm just trying to instill some real life practicality into all these matters, because if we just deal with this, just deal with the case before us and nothing else, it's a gross disservice to the parties, because nothing will change behaviorally. And I want everyone just to think about something. If either side extends some sort of olive branch, indirect, even if it's indirect, which I think this photo thing, I think it was sort of an attempt to the whole thing blew up.
No, it
But on
wasn't.
some level, it did seem to be some sort of attempt to extend an olive branch. It didn't really have to do with the picture per se. It was about maybe if he knows that this is someone I'm associated with, and I want to get these photos of delighted parents and child at this sporting event, maybe things start to thaw. So the next time one of you indirectly does something that seems to be geared to reducing or de-escalating matters and creating a more proper climate for an 8-year-old girl, the taking these hard stands, well, why should I sit for that photo with this SOB who, I get that. And the fact of the matter, the rules change. When you're single, you can do that. When you have children to protect, it becomes about that and what the dispute, how the dispute harms them. That's what the focus is, not who's mainly to blame for it, but how we could have avoided it.
Exactly. You know she's batshit crazy, so you have to mold yourself around her crazy to de-escalate things. No, you don't.
Get in the middle, tell you, please go sit on the bleachers, let me deal with this. Get between them, anything, I mean, but I don't think that, I don't think you guys should be pursuing this in a criminal court realm, but that's up to the two of you. I think that's extremely damaging to your daughter, to see you guys not only fighting over custody, but reporting each other to the police. But I've said my piece, and I've said it over and over. I tried very hard to be helpful, offering my legal experience, years of life experience in these matters, and that's all I can do. All right, so that's basically where we're at.
Okay, just a couple of minor things, Your Honor. First, a correction, the decree does allow, or the stipulated decree does allow for the parties to elect either a family member or a third party to conduct the exchanges. It isn't ordered that the parties themselves have to specifically.
Why would he want to send?
Well, my client
Even
works, Your Honor. I mean,
even if he were to say, Kimberly started a dispute, why would he? If he knows it's going to occur, why would he send his wife over? And then after the fact say, yeah, but we aren't the ones who started it. If common sense and life experience-wise, you know something's going to happen. Why does he have to send his wife?
Your
He
Honor,
can't send his wife anymore.
Your Honor?
Yes.
So the way we did the exchanges and the visitation days, there's only one day a week that there's actual contact at Starbucks, except for when school's out. Because each parent would pick the child up from school and then drop them off at school, the next parent would pick them up. At Starbucks, what we agreed to before, the parent delivering would walk Aslan to the front door.
Donald, I would love to get lost in a parking lot with you again. For 4 hours this time.
See the other party there. Aslan would walk to that other party, and there's no conversing, no contact, no nothing, and never has been.
Well, after someone.
And I don't do my exchanges, Your Honor, because I'm at work.
Right, but each of you claiming that the other side battered you at a softball game, or whatever it was, soccer, that's not good. Someone could easily walk through the door and would, and so your suggestion is to, what, eliminate? He's gonna have to
I
find
don't
someone
mind
else.
his mom, I've asked that his
Oh,
mom.
okay, but,
can-
okay.
can-
If you
or
wanna
I
be,
can
if you
look
wanna
at
be
her.
protected from the person who you say attacked you, well, he said you're the one who attacked his wife, and I'm
Right,
not a
then just
fly on the
have
wall,
us
I
around.
don't know, I honestly don't know. But we can't start going through this list, okay, you understand not liking his mom is a lot different than, can his mom effectuate a peaceful exchange
Well, she
and just
can,
walk
I
to
don't
the
have a
door?
problem with that, I've always said that, so that's what I've
So
asked.
whether you like his mom or not, his mom is not his
No,
wife,
no,
his mom's not gonna
problem.
attack you, right?
Yeah,
Okay.
his mom's fine,
So, the agreement would be,
Yeah.
you don't want his wife at the Starbucks exchange under any circumstance.
correct, I don't. it's
And I
just
agree
around
with you,
each
because
other.
I'm not gonna, because of what happened at the game, that they boxed the court into issuing the only order it could on that.
Right, I'm fine
She
with that.
and his wife cannot be like within 1,000 feet of
I
each
agree
other.
with that, thank you.
So, who's gonna go? She said she doesn't like his mom, that's.
His mom's gonna go do the exchange.
No, I don't want, I never said I didn't like his mom,
Oh, I'm sorry,
never-
okay.
I never said that, I said I would prefer his mom,
Oh, I'm sorry, okay, so,
yeah, his mom, perfect, yes,
Okay.
thank you.
And then,
so that will be a third rule. My first ruling is the court reserves the right for the new judge to lower the support if there's a basis to do it, and it's retroactive to the day of the stipulation. Two, the court's going to explore the recusal, which hopefully will occur, which will be to the delight of everyone, not just Kimberly, but your side, since your focus is just rule on what's before you, and I'm not gonna guide my client how to save money and reduce conflict and reduce all this, because that's what I'm getting here, is that no one seems to wanna take no one's looking ahead. No one's looking at the psychological behavioral dynamic. No one's seeing how nothing is gonna improve or change unless one person there's an adult in the room and takes the bull by the horns and says, I'm not gonna expose myself to conflict. Someone can disparage me all they want on the internet, but I'm not gonna get into any confrontations that become physical under any circumstance. And your client probably, if the police arrive and it's a little muddled what happens, who do you think's more likely to be taken in as a practical matter? If it looks like there was a physical dispute and it's a little difficult, who's the primary aggressor, or a solid case could be made for either of them.
I mean, my client's trying to leave, Your Honor, so,
Well,
but I won't get into
maybe
that.
not
There's
him, but
criminal
more to the, well, you're right, more to the point, they're gonna be looking at the two of them. But, so
and
that, and two, the court will explore the recusal, and three, on the Starbucks exchanges, the paternal grandmother, if dad's in a pinch due to work and cannot be there, the paternal grandmother.
And then,
will
Your Honor, for the
effectuate
hearing on
consent.
the 24th, since my client does have work, can parties' appearances be waived, or my client's?
We can move it to a day where,
Oh my God. I just looked at how much a private flight would be from Lancaster to Houston. Oh. 25,000, 30,000, $45,000, not pesos. Oh, that better come with dinner. I better get more than a packet of peanuts. Wow. Oh my gosh.
what day of the week is it?
Let me look at
What
the
days does he
calendar.
work?
I work Monday through Fridays, so
Pardon?
just in the morning would be better.
I'm sorry?
I said I work Monday through Friday, sir, just the earliest possible time would be work so I can go
What
back
time
to
do you
work.
start?
8.
So,
So he'd have to take off.
I took
anyway,
today off
it's
of work,
just-
sir.
Oh,
So that he doesn't
so-
have to take the full day or, you know,
so basically, any day of the week you'd have to take off work?
correct?
Yes, sir.
Okay. Yeah, sure.
Preferably,
I
I'd rather
don't
take
know.
the morning off so I can go back and,
If either party or both party want to appear via video, as long as, probably may not even be on the case by then, probably won't be, but
Yeah.
I don't have a problem with that as long as the video feed is adequate.
okay,
All right, anything else for today? Anything else for today's purpose?
No, Your Honor.
Okay, thanks, everyone.
Yes.
Opie Patty vs. Hurd matter D 62266.
I'm not paying that. I don't care if I had $100,000.
Hearing, can everyone state their appearance for the record, please?
Good afternoon, Your Honor. Chris Phillips, bar number 14600, standing in for Mr. Friedman this afternoon. He wasn't available on short notice. We're counsel for Mr. Opapari, and then also logged in with me is my paralegal, Tracy McAuliffe.
Excellent. And whom else is present?
Kimberly Joy Hurd, defendant.
Okay, now I did read the ex parte motion as well as the response. Did you wish to add anything to your motion? Then I'll ask them if they wish to add anything to their response.
This is Kimberly. No, I have been very ill. I'm not lying about this. I'm not going to make up some agenda to do all this just to not go to trial. That's not my intent whatsoever, because this only delays what needs to happen. So I'm not happy about this at all. So unfortunately, I don't have insurance, so I'm not able just to go out to go get a doctor's note. If that's what's required, then I will work on this afternoon finding somewhere I can go.
Okay, did you have anything to add to the response to the opposition to the motion?
Very briefly, Judge. So I think our response was pretty clear. Our concern, as the court knows, is that, at the time Ms. Hurd made the request, it seemed speculative, right? She asked last week to continue this week on a theory that she might still be sick. Obviously, if she's getting out of bed for the first time today, nobody begrudges Ms. Hurd for being sick, and we don't would hope that we would have received a similar accommodation if Mr. Friedman and I were also sick. That being said, I can't not at least mention for the record that there's at least a history of Ms. Hurd being unprepared and missing trial. That's certainly part of how we got to where we are today. So I'd like the court to note that, but certainly I understand that if, Ms. Hurd's still sick and is not able to go forward, then certainly we're not gonna object too strenuously. But in sort of moving it forward, Judge, I would just ask the court and sort of looking at the calendar that we not look for any dates the week of the 19th to the 23rd, just because Mr. Opapari is not available that week. He had a pre-existing commitment that week, and I wouldn't be available to have the client present.
So you're saying no dates the week of
19th to the 23rd,
the 19th of March?
February, so a week after next.
Well, we're not gonna be, if it's continued, we're not gonna be in this month. We'll be in that.
Fair enough, Judge. Fair enough. I just,
Okay,
in the event
did
we
you
had
have any
availability.
response to what the attorney just indicated? Is there anything you wanna add?
Only, Your Honor, I don't have a history of missing hearings or trials, and I certainly don't use making up being sick to try to miss anything. This was a year and a half ago, that trial. We've addressed it. It's like beating a dead horse. It has nothing to do with this trial. Whether I'm prepared or not, I know that ignorance of the law is not, in fact, a defense to the law. So I am not doing this in any way, shape, or form. I've been at the last 3 hearings, and I'm fighting through to get through that. I'm not using this as a mechanism for that. I'm physically in every single hearing. This is the first hearing I'm even on Zoom. I'm physically in your courtroom every single hearing. I don't like hiding behind a screen, or I like physically being present there. So I don't have a history of doing this. And in fact, it was Mr. Friedman back in October who filed an ex parte motion without serving me, without asking me to move that hearing. And I didn't get to object because I wasn't even served. So I don't have this history. In fact, it's what they do. I just want to get feeling better. I've not been able to see my daughter, where they say that I'm still visiting. No, I've had to cancel my visitations with her because I am so sick. And I don't want to get her infected, because if she gets sick, it's far more severe for her. So I'm not even able to see my own daughter. And to suggest that I'm lying to the point that I'll have my parents testify if they need to, and to the fact that I'm going to miss seeing my own daughter as an agenda just for a trial date, I kind of find a great offense to that. And that's all I have to say. I'm genuinely sick, so, I'm not going to sit here and I don't have an agenda. I just want to I want to go forward. I want to have my daughter back in my life, and this has been a delay that does not make me happy in any way, shape, or form.
Okay. Guys, you can pick Wednesday, March 20th, 9 and 1:30, or Wednesday, March 27th, 9 a.m. and 1:30. Take your pick. Any
I would
preference?
be okay with either date. I'll let
Okay.
opposing counsel decide.
The March 20th would be better for
I'm
our
sorry,
count.
which one?
March 20th would be better for our
Okay,
count.
so March
20th?
20th at 9 a.m., since this is a continuation of sessions
So
5
we're gonna
and
do-
session 6, can we enter March 20th, session 5 at 9, and then a separate session 6 at 1:30? Okay, thanks so much. All right, that'll conclude the hearing, March 20th, in court, of course.
Yes,
At 9
I appreciate the
a.m.
court's
and
time
1:30.
and
Okay, feel
Mr.
better.
Phillip. Thank you, I appreciate it.
Okay, we're on the record on the Opari versus Hurd matter, D 622669. May we have appearances?
Damn, I thought I checked this and they were in order. They were in order, but this is just a motion for access to medical records. Okay. This was in March. So yesterday we were in January. Today we got to August. And now we're going back in time to March. I thought I checked these and they were in order. But this one's not.
Yes, please.
Good afternoon, Your Honor. Matthew Friedman, 11571, on behalf of Mr. Opapari, who's not with me because I'm currently laying in my bed.
Okay, understood. And other appearances,
And-
please?
And Kimberly Joy Hurd, defendant pro per.
Very good. Now, the reason the court, not only on this case does the court want to be careful, make sure everything's on the record and everyone has a right to be heard, but that's a situation which applies to most contested cases for obvious reasons. Anytime a continuance of trial is opposed, the court hates to just deal with that request ex parte, so it requires to be dealt with on the record, even if it's difficult for the party requesting the continuance due to being ill, and so we appreciate
I understand, Judge.
That being said, we did continue this last time when Kimberly was ill and
Yes.
requested. So, Mr. Friedman, just as to the extent you feel comfortable, just since it looks like out of necessity, you kind of have to. You can go ahead and fill us in about your current situation relative to the illness, and we'll go from there.
Sure, Judge. So I was actually out of town last week with my family for spring break. We were up in Utah, and we were coming home Sunday morning. Both my son and I woke up on Sunday morning with some kind of respiratory virus of some kind. I'm not really sure what's going on with it, but it's just a lack of energy, wheezing, that kind of thing. It's my understanding. I guess this is sort of going around, which is unfortunate. It's, I never want to try and move something last minute, but there's no way I'd be able to put a trial on tomorrow, Judge, or in any meaningful way. And while I certainly do have other lawyers in the office, none of them have worked this case and been part of this trial. It's just not fair to my client to put him in that position. So, and we want to wrap this up, but just request the full day setting as quick as you can get us one. And I know we've all agreed that should be the last day, and we can put this thing behind us. I'm sorry it can't be
I don't
tomorrow.
agree with that.
Although I may be in a position where it may unfortunately have.
He doesn't know their
to be
names.
separate half-day settings rather than the full day, which we lucked into this time.
I understand.
But we'll deal with where we're gonna
Every time he asks them their names, they say, "What do you want my name to be?"
set it in a minute once it's determined if it's continued. So it sounds like you want to respond to what Mr. Friedman offered, so proceed.
If I could, Your Honor, I would appreciate that.
Sure.
I don't have an issue continuing the trial for tomorrow if he's sick. Obviously, I went through this 6 weeks ago. That's not my issue. My concern is I have not been allowed to obtain documents from my daughter with her school, with her medical records. And my daughter now has a surgery that I just only found out about, scheduled at Sunrise Hospital on Friday, going under general anesthesia. And I cannot obtain any information, very limited information. And I am highly, highly concerned because this was a matter that I addressed to the court back in November regarding her dental decay. And now, all of a sudden,
You understand,
she has surgery
and
Friday.
you understand here that this has been, this isn't like 20 years ago where one parent was the gatekeeper. I went through this. I asked you, are you on the list with the school and with all the med providers?
I'm not. He has
And
not
if
put me on there.
And if not, over and over I asked, what do we need to do to get you in, the password, the bank, what is it that you need? What does he need to send you? Why are you still having difficulty?
I need some kind of documentation. He is telling all the providers, he's putting passwords on her account. He will not, he says he has sole custody. He will not allow me to call them. He will not allow me to go there. He will not allow me to get information.
Okay,
I've sent the audio to you. I'm asking for a record.
The court ruled in your favor on this and repeatedly. So
Yes,
Mr.
and I haven't
Friedman,
gotten any
hold on.
documentation. Here it is
Okay,
3
Mr.
months later
Friedman,
and nobody's gotten me anything.
Thank you. Mr. Friedman, what's the problem? Because I don't really have much patience for these type of issues where.
I don't even know what she's
Particularly
talking.
these days
I
when
don't
it's a
know.
quick fix.
What do you mean you don't know? I've sent you
Know what
letters and
she's talking
emails.
Okay.
Judge, I really don't know what she's been
Can
at
you look at my
every.
exhibits appendix, Your Honor?
appointment.
Please.
What,
She's been at every single
okay,
therapy
the order,
appointment.
the
Because
order
she's-
enabled.
I have to hide in
Thank
another
you,
room,
thank you,
Mr. Friedman,
thank
because
you.
of Carrie
Thank
assaulting
you.
me.
Thank you. The order enabled you, which I dealt with.
I don't
this
have an order,
Thank
Your Honor.
you.
I don't have it.
Yes, there are. It was told
I
several.
don't have it. I can't
Hold
get
on,
what I don't
hold
have,
on.
and I can't do it.
Hold on. Again, this was dealt with repeatedly. And here's.
Yeah, it was, and they're not doing anything, and my daughter has surgery in 2 days,
I've
going under
done
general
everything
anesthesia.
about it repeatedly, but you're not listening. If you please listen, this problem was
Okay.
solved many, many
Okay.
times ago. I said as follows, and I did this more than once.
You did solve it,
Several
but they
times.
haven't done their
Would you
end.
please like to hear it so you know how to correct
Yeah.
the problem?
I'm
Thank
sorry,
you.
I'm just very
That
anxious
Kimberly
because of her
is
surgery.
The order is going to empower you to make certain that he is compelled to transfer the passcode to
Right.
you, and that also you take
Yes.
the order to all the providers.
Okay, so
that
could I
they-
get that today from the court?
Hold on.
I would appreciate that,
Okay,
please.
and
Can I
not
get
only
something
did I
today
say
from the
that-
court?
now, hold on. Not only did I rule that, but I said, if you need a separate order to that effect, separate and apart from, because we're not going to delay your right for that just because your case isn't resolved with a final order as to custody. If you
Okay.
need a separate order on that, I said I would not only be willing but delighted to sign it. If you want the court to draft it, because you and Mr. Friedman can't figure out
Okay.
how to solve this issue. Did you inform Mr. Friedman of this?
Yes, I've sent emails, and they're all in that exhibit
Okay.
appendix I filed today on an emergency. I have numerous emails, Your Honor. I have been
These-
trying, and I'm
these-
highly,
this
highly
isn't the
concerned. I am not
1990s. For this
just
to be
coming up with this
persisting
to be
is nonsense.
difficult.
Judge, you have to get this woman in line, sir. I'm so sorry, but this is
That is so
every single
disrespectful. Your Honor, I'm not
proceeding. This is
station
every
him.
single proceeding.
Oh my God, finally. Oh my God.
She runs roughshod over the court.
That is very
She speaks over
inappropriate.
you. She speaks over everyone.
Okay.
She shows a lack of
Okay.
any kind of
We
courtesy
can
for the
deal
court.
with
I
all
don't
that
even
in-
know
we
what
can
I'm
deal
here
with
for
all that
today.
in time if we have to. Why is this still a problem? And in fact, before anyone
I
brought it up.
don't even know what
the court
she's
brought it
talking
up on its
about.
own initiative. Are you having
No,
difficulty?
no, Judge, that's not what occurred.
I have
We
no orders, Your
stipulated-
Honor.
Can
Yes,
someone
it
please
is.
tell me
Yes, it
who's
is.
speaking?
I'm not gonna be, this is disruptive to the current case. I thought all we'd be doing is looking at new dates. But she's saying that her child's going under general anesthesia, and the court, on its
Friday.
own initiative, and don't anyone say no, because the tape is our friend, the record is our friend. I've initiated discussions like, are you having difficulties? Do you need portal and password numbers? To what? To each individual physician, to the school, and I will compel him to provide it by Friday at 5.
Okay,
We've dealt
please
with that
compel it.
repeatedly. You guys
Please,
listen
by
to what you
Thursday.
want to hear? You're too busy thinking what you want to say next and be contentious, so you're not hearing it. What specifically do you need that this order is, that you can't, why can't you submit an order to the court? In fact, why don't we have it that way?
Okay,
You will
I didn't
identify
realize
right
that was an
now-
option, so-
You will identify right now all of the healthcare providers in the school, or anyone that you need information from, and the court will indicate by this Friday at 5, he'll send you all.
She has
portal
surgery
or password
Friday morning at
information.
6 in the morning, Your Honor.
We're not talking about that yet till we talk about what we're talking about. Do you want to jump to that issue and ignore this one, in which case I won't address it? Or do you want to work through this issue that is of such
Okay.
concern to you?
Okay,
Do you want to work
So
through
can I
this
get-
issue, or you want to jump at something else?
no, so can I just make a request? You said that I had joint legal custody back on
How
January
do we,
6th. You
I
gave
don't
me
want to
joint
get
legal
sucked down the
custody.
rabbit hole here. How do we solve this? What kind of order
Can I
do
have
you
joint
need
legal
to solve
custody?
your
Can I get it
problem?
in writing? Something in writing that I
Yes.
have joint legal custody.
Yes.
That would give me everything I need. That's all I need.
Yes, okay.
Thank you.
Mr. Friedman, what's going on?
Can the court draft it, please? Or I will. I
No,
will.
then
I'll
you-
do it
you
today. I
probably
can do
use
it. I can do
Otherwise
it
you'll say
today.
it's wrong and it's not what you want. Okay, Mr.
I'll do it. I'll do
Friedman.
it today. I can do it.
Mr.
I just
Friedman,
ask that we have
with
the ability to review
with the
countersign,
understanding
Judge.
that if joint legal custody and joint physical custody and all this remain disputed by the court, we can issue an order that doesn't even deal with these distracting labels. What about an order that said Kimberly is entitled to present this order to any education agency, any
No
healthcare
objection.
provider, and it'll be released?
No objection.
Okay. Okay.
In fact, Judge, we
Would
were
you
the
like
ones
to
who
submit
stipulated.
that order tomorrow and I will sign it?
Are you asking me, Your Honor, or?
You don't even have to get Mr. Friedman's signature. You can.
Okay.
still.
Yes, I can do that, Your Honor. I appreciate that. I can do that.
I would very much have an issue, though, Judge, with not being able to review what's put in that order
You
and
can. It's
countersign.
gonna delay. I don't want to bother you when you're ill. We're not gonna sign it if it goes beyond what's indicated here today. I'll make certain that if you want, she'll send it to you first.
Judge, if
we're so
you're gonna-
caught
if
up-
you're gonna-
since we're so-
if you're gonna handle it, that's fine.
Since we're so caught up with custodial labels, there will not be a designation in this order as to how it affects anything legal or physical, or
Okay.
anything like that, if that still remains an issue. Just that she's entitled to present this
Specific
order
record.
to any healthcare provider, any school, anywhere, and get information, including portal, passwords, et cetera.
Stipulated.
Has she sent,
Stipulated.
has she sent
Okay.
this request to you? Okay. Submit
you.
it by tomorrow. I'm sick to
Okay.
death of an issue that I, in fact, have brought up many times and told you exactly how to solve. Now, what operation is occurring Friday?
My understanding is it's just it's dental work, where they're
Yeah, but it's
extracting.
going-
Dental
sorry.
issues are seldom general anesthesia.
No,
treatment.
it's a
Yes,
tooth, it's a tooth
exactly.
extraction. Judge, it's a tooth extraction, and the reason
No,
that
Well,
it's
is,
not.
that is a little more serious.
the reason that she knows about it is because she was provided notice
By whom?
No, I wasn't.
by
Only
my
2 weeks
client.
ago.
Okay.
No. He's known about it since for
Okay,
3
is
months.
it, okay, is it that you're opposed to this, or just you lack information and you're not sure how?
I'm
you
opposed to it. She's getting a stainless steel crown. I do not want stainless steel in her mouth.
My
it,
She's going under
8-year-old
general anesthesia. That's a
my
very serious
8-year-old has-
procedure.
Is it that you're opposed to it, or you haven't gotten to speak to the specialist?
I have not. Carrie Anderson is the one who authorized this surgery. She has no authority to authorize surgery for my daughter. Mario did not authorize this surgery. Carrie Anderson did.
His mom?
So, yeah, his girlfriend, well, now wife, they're married.
Right,
So I did not, Mario didn't authorize it, I didn't authorize it. Carrie Anderson signed the notice and authorized it. I have and she presented herself as the mom. It's in the records right in front of you. I've filed those.
And
She has
isn't it a
said that
little-
she's
isn't
the
it a
mom.
little I understand your concern, but isn't it a little unreasonable when?
I don't know, 'cause I don't have the
when-
records.
When the court, in deference to you, instead of just entertaining this continuance request based on Mr. Friedman's representation that he's seriously ill, instead set this where it interferes with someone else's case.
Okay,
Gets the,
I-
hold on,
I'd appreciate
gets
that.
the court all
Right.
worked up, and then bam, you hit us with it right between the eyes. How can I make a sane, rational in order if
Because I
I
just
haven't
found out last night,
interfaced-
Your Honor.
haven't
I was
interfaced
just found
with the
out.
Hold on. I haven't interfaced with the dentist, physicians, and the dentist, anyone else, to determine, it's not my determination. So what am I supposed to say? This extraction should or should not occur this Friday? You know how ludicrous that is?
I know, and to say that I'm
Well,
supposed to
I
go
think-
forward with it when she's going under general anesthesia, when I
Okay,
just
and
found
you-
out last
If I
night.
can-
You guys
if
are
I
hitting
can
me with
say-
this-
if I
you
can
guys are
say
hitting me
two
with
words,
this issue on a
If I
Tuesday
can
afternoon.
say two words.
That's why I wanted to
and
talk to you tomorrow at trial. That's what I was gonna bring up, because I just found out last night.
If I can say two words,
What do you know
please.
Yes,
about it?
Mr. Friedman.
It wasn't last night. We were informed about it weeks ago.
I was informed that it was at Sunrise
Miss
Hospital
Hurd,
last night.
Miss Hurd, can I please get two words in?
Good luck.
Okay. The situation, my son has, I believe, two, if not four of the exact same things. It's basically a temporary crown where you have a cavity in the very back molar. What they do is they use a lot of drilling to go in and drill out the decay. And instead, because it's a baby tooth, instead of going in and doing a permanent crown, which would make very, very little sense, what they do is they put a stainless steel cap or crown on top of the baby tooth once the decay is gone to prevent further decay, and then the tooth falls out on its own as part of the aging process. Okay? It's very, very common. This is not, and the reason for the anesthesia is simply so that the child, with a drill in the child's mouth, and a special needs child, the dentist did not feel that it was something that could be done with, for example, Novocaine only, which I certainly can understand because they did the same thing to my, at the time, 6-year-old who's now 8. Okay, because he was the type of a child that might well move his head even though he shouldn't, and now you have a dental drill in a child's mouth, the child's jerking the child's head. We can all understand
You're
why
not
that.
my daughter's doctor, though.
No, I'm not. I'm just trying to offer a
So
little
your
common
anecdotes are not gonna
sense.
help right now, please. I'm
Just offer
sorry.
a little common
Okay,
sense approach to what is being very, very
Okay,
exaggerated.
is the
Common
objection,
sense is
is
not-
the objection here that you don't like the messenger, that it's him and his wife who were behind this, or that you've done a deep dive on this and you think this is a really bad procedure that shouldn't occur? Is it both? Which is
Okay,
it?
Your Honor, I've done a deep dive. I wasn't able to obtain full record, so I'm not fully aware. I know that she's going under general anesthesia, and I don't care who it is, what it is, or what it's for. That's a major procedure. And I only
And what
found
do you
out about
expect
the
this-
general
what do you
anesthesia
expect
last
this
night.
court
I would
to
like
do?
more
What
time
do
to
you
get
expect this
information,
court to do?
please.
What
Can we-
skill or expertise do I have? And I haven't, even if I had the skill or expertise, I haven't
Okay.
examined him. What do
I'm
you
just,
expect this court to do?
I'm just asking that, can we postpone this just temporarily? I'm not asking for months or a huge delay. It's already been 3 months. That there at least be time for me to review the records and the chart and talk to the dentist and have a conversation so that I know what's going on as well. That's it. I'm not asking for it to not happen. I'm just saying, can we postpone this? Because I don't
court-
know.
Well, you're thinking along my lines too with one provision.
If she wants
Hold
the
on.
child to continue suffering,
Well,
then
okay,
He's
don't
not suffering.
stop assuming the court's a total moron, even if it is, okay?
Thank you.
Of course, you know the second half of my sentence would be a possible 30-day postponement, not period, but comma, providing the dentist reduces to writing that it is not unduly harmful and that he is not, that Tanner is not in any not Tanner, but an
I know,
unnecessary.
I would appreciate that. That would be fine, please, please.
Which means that you and Dad have to have a joint discussion with the
Yes.
dentist, like, tonight, tomorrow,
Okay,
Because that's probably all we're gonna be able to do.
Okay.
If-
I'm okay with that, Your Honor.
We're
Thank
not
you.
gonna really have time ultimately for it to be reduced to writing, but for now,
Right.
you contact the dentist, arrange an
Okay.
emergency conference, and you accept the recommendation of the dentist. You tell them what
Okay.
you think, you ask your questions, then you
Okay.
accept what the expert says. Are you willing to
Okay.
do that?
Yes, I appreciate that, Your
Okay,
Honor.
now, are we gonna encounter BS, we couldn't both get them on the phone at the same time, or what?
If you're asking me, Judge, I have no idea, but I'm happy to try. I mean, I'll have my staff reach out immediately. I don't know why it would be an issue at all.
I'll play the tambourine.
I mean,
Could've
to
been
me, it's
handled a
normal
long
dental
time
care,
ago.
but my
You
understanding,
realize
Ms. Hurd
neither
is
Mr.
very
Friedman or
skeptical.
I heard anything about this till right now, okay? And we weren't even gonna be here today, except the court in an abundance of caution and fairness to you, because you're unrepresented. If it was an attorney on the other side refused, I probably might have entertained this, without setting up this hearing.
Okay.
Doing a
I
great
appreciate that, Your Honor.
disservice to this young couple on before, because now they have to conduct the rest of the afternoon with me even far more aggravated than usual.
Okay.
It's grossly unfair to them.
I get it.
Good.
Agreed,
I'm
Judge, so
glad
I'll
we
update my
understand
staff
there's other
accordingly.
people
We just need-
impacted by our actions. Okay?
Your Honor, could I just ask for some time for Easter next week, since it's next week? And
So we're jumping to something where we don't even know if this, no, the answer to that should have been, how do we
Yes,
set
I've already
this
asked
up?
for it,
How
and
do
I
we
was
set this
ignored.
up? It should be questions like, gee, when can we, both parents, present a united front? Some tentative times, one or two, when can we try and call in tomorrow?
okay, I'm available whenever Mr. Perry is, and I can send him a message right now and ask if you want. Actually, I can do that right now.
Okay.
So, Judge, I think we
Is-
just
is
need
Mario-
dates so you can
Is Mario
get
on
here.
the feed?
We need a drummer.
Mr. Friedman?
He's not, Judge.
Okay.
I'm
Will
pretty
someone
sure
from
he's
your
working right
office
now.
Convey to him that he needs to.
I will absolutely immediately have my staff reach out to him, and I know he's
If this doesn't occur, I
working.
don't have the ability to interfere with it, and I lack the ability, even if it involves a child under this court's jurisdiction, it's probable that I don't have the ability to direct a third-party physician what to or not to if it's within the line of what they consider medically necessary.
Right.
Plus, they have the authority of at least one parent, the parent with the custody. So I don't think I'd be able to interfere in any event.
Well, I heard, Your Honor. I certainly will have my office reach out to Mr. Perry and to the extent it is possible, coordinate a call with these two parents so that they can hear the same thing I just told you about the dental procedure.
So
But
Aslan is, she's not quite 8 yet, is she? What is she?
Yeah, you're right, 8 in May.
that's
Okay.
correct, Judge.
Okay. You guys, I swear, this case. So,
I agree.
you understand, and your office will help arrange with Mario, not you, I expect you to delegate this and you
Of course,
concentrate on
Judge.
getting well, but you have them coordinate with both of them, contact the dentist, say, even just
I will.
5 minutes, no matter how busy, can please, because of any effect. And they'll take the call usually from my experience when these last minute things arise, because particularly if they hear, a case involving lawyers, and they don't, once they hear lawyers, they won't proceed with that without taking that call, so.
Sure, I will do that, Judge.
Okay.
I think we just needed dates
Okay.
or a day.
Now, I'm looking, and we're really slim pickings here. Looking at Wednesday, May 3rd at 1:30, and then Friday, the 5th at 1:30, that week, just 2 weeks from now. Take a look at your calendars. If we don't take those
Mark,
dates.
you're saying May? You said it's a month, right?
May, no, I'm sorry, you're correct, April,
April.
that's correct, thank you. April 3rd Wednesday at 1:30, and April 5th, Friday at 1:30.
Okay, I could do both.
Mr. Friedman, is your calendar at your disposal at this time?
Sorry, Judge, I think I had you muted.
And
It
Mr.
is
Freeman, I
not,
understand the tenor of this hearing is not conducive to your improved health or your recovery, but
I
it'll be all
understand.
over in a couple minutes.
that's okay. I'm looking here. The 3rd, I think that looks like I'm open. It's tentatively booked, and yep, I should be fine on those days. Or those morning or afternoon sessions, Judge.
Okay, so session, whatever, is it 4th session or what number is it, 4th?
I think it's 5th and 6th,
5th and
right?
6th, okay, if that case, session 5, Wednesday, 4/3 at 1:30, and session 6, that Friday, 4/5 at 1:30. That's number one, that it's continued due to seems like a pretty serious health situation. And plus tit for tat, there was a continuance on the other side for a legitimate health purpose. Number 2, the court's made it clear that its authority to halt this operation that a physician apparently will indicate is medically necessary and was authorized by the custodial parent, that the ability of the court to issue a cease and desist to that third party is highly debatable at best, and instead, that would be irresponsible for the court to interfere and doom a child to continued suffering because of a conflict between the parents. So we're gonna put it in the hands of the specialist. And if the specialist believes Ashlyn will be harmed and the situation will exacerbate and her pain will increase and all of that, that's where the focus needs to be, not these power struggles.
Bill's in Florida. So no, he's not cold. No, I don't even care what degree temperature it is right now for him. It's not cold.
Between the parents. And number 3,
Not a parent.
if you want to submit an order, tomorrow, just limited to presentation of this order, will enable and direct all, however you want to phrase it, educational, just don't make any custodial
I thought he just got home.
references, just child name and date
Educational
of
and
birth
medical.
and the presentation
Weren't you driving and drinking all day yesterday to get home? Or were you drinking and driving yesterday to get away?
of this to any healthcare providers, educators, everything entitles you to the portal, the password, everything, whatever it is.
Okay,
And this probably all could have been handled, Dad could probably have just given you all these passwords.
well, I asked
weeks
about
ago.
10 times.
Weeks ago.
Yeah, I
And
did, I've
ordered
asked.
them
He's-
over and over and over. So no more
Yes, I've
nonsense.
asked him.
So, Mr. Friedman, if you do
Okay,
want to
thank you.
review it, she can send it to you. I assume she has your, attach it to an email and whatever. And if there's a major problem with it, you.
Sure.
Yeah.
I doubt there
No,
will be
and
based
whether
upon
there
it.
is a problem with it, it doesn't affect this other issue. They both need to be on the horn with the dentist tomorrow to resolve this.
Okay,
Yeah, well, I
Thank
don't
you, Your Honor.
anticipate a
And yet
major issue.
another,
being
yet
promoted.
another issue is there were a bunch, Kimberly dumped a bunch of new, these white binders over. And I don't wanna get devoured by hours of arguments at hearings about lack of sufficient notice and surprise. So, Mr. Friedman, this will give you time also to review those matters so we don't really get sidelined with a lot of discussion about, relevancy and other things is one thing, but we don't want it to be a big argument about lack of sufficient notice or something sprung. Are you aware of what she was bringing over for the court?
I'm not, Judge. I think she tried to drop, when I was out yesterday, she tried to drop a slew of binders at the office, and given that the case had already been through 4 days of trial, I think my associate, Mr. Brown, indicated we weren't going to receive a slew of additional documents in trial binders in a trial that's already been through 4 sessions. I've never heard of that in all the years I've been practicing, so I don't fault Mr. Brown for his response. I mean, if Your Honor feels otherwise, I guess.
No, I
That could
don't,
be a
I just,
decision for you to make.
I just don't, I mean, I agree that no one should be blindsided like that, but if we now have a continuance, if some of those can be reviewed, if they're objectionable for other issues such as foundation, hearsay, relevancy, but I just don't wanna get sidetracked with that they're not admitted because they're not, lack of sufficient notice, or they're sprung on us too late, so at least if you could.
I mean, Your Honor, Miss Hurd had, I don't know, some 100 exhibits, and she's admitted none of them through 4 days of trial. So I suppose another 100 exhibits, if she doesn't admit those either, won't really
Okay,
matter.
what's the, without, just the Reader's Digest version, what is all this new buckets of documents about? What does it concern?
I have given him notice. He was on notice back in January. I just couldn't get them into binders
What are they?
because they are Aslan's medical records. Most of them are medical records.
The
They're
medical records
emails.
that
They are letters
apparently it's
to and
impossible
from.
for us, you to obtain.
Nevada.
I'm sorry,
The
what?
medical records which you got through telling us you can't possibly obtain, never mind. Mr. Friedman, if we have complete sets of medical records from any healthcare providers, those will probably just be admitted presumably, but I don't know.
I don't have an objection to medical
Yeah.
records, Joe.
But we'll cross that bridge at that time. So we got our dates, anything else for today? I don't want BS, I've given these two the ability to
That's
cooperate,
fine.
get hold of the dentist, I don't want anything about, oh, I wasn't available, or I'm working. Anyone can set aside 5 minutes to discuss their daughter's operation, which the one side thinks is potentially harmful to her, and the other side is convinced it's harmful to her if we don't go through this, and she's consigned to a lot of pain and exacerbation of that condition. If that's how Dad feels, which he apparently does, I will tolerate no BS, that we couldn't make this happen.
Lies.
Let's blame it on the other side that we couldn't schedule this. So you guys need to put your heads together. Mr. Friedman and his office will do, and always does an excellent job with these things. We're gonna make that conference happen. And if it
Okay.
happens,
Judge,
and the physicians, if he is willing, if the physician says, I will put that in writing, this could wait. I don't, she doesn't seem to be reporting undue pain or discomfort, and I don't think it'll exacerbate or worsen the condition. If he's gonna put that all in writing, which he won't, then it can be delayed a month. But if not, you've gotta have faith in the physicians who treat her and not try and nullify that treatment because you don't like the messenger, that it's him or the other side. So that's all we can do today, folks.
Understood, Judge. Thank you for your time. I apologize for taking
problem.
the court's
Feel bad.
time up and other litigants in the courtroom.
Feel
I
better.
apologize. Well, thank you, Judge.
Thanks so much.
Bye-bye.
Your party was heard matter,
We're on the record.
D 622639. I believe this is evidentiary.
Damn.
Session 5.
Damn. I don't want to stop. Oh, wait. I don't think I can stop. Because if we're going to get through this tomorrow, we still have another almost hour to go today if we're going to get through this tomorrow. I guess we could put that one off till tomorrow and go a little long tomorrow. So we'll do this 26-minute one today, and then tomorrow we'll go a little long too, and finish up the last one. And gosh, I just hope they're in order. I mean, I double checked yesterday with y'all. Part 17, Part 18, Part 1, Part 2, Part 3. So it looks like they're in order. All right, let's do this one. I don't want to stop. I'm not in the mood.
Session 6 is on Friday. This big to do about all these binders and exhibits, and the
It's supposed to be 4:30 Eastern Standard Time. So, but I was late today. Late. So, it happens.
I didn't really have any helpful suggestion beyond all on all this beyond the obvious last time, which was you can't be inundated with last minute changes or alterations or additions and additional binders, but that even if the deadline is long past for submissions of exhibits to the court and the opposing side, if someone just has 2 or 3 key pieces of new information and provides it to the other side in advance, it probably handles most of the objections as to that. For example, last time I was telling you, it was many weeks ago, if there's a few key new pieces of information you have, send them to Mr. Friedman in advance, and if he objects that they're late, there's always an argument he still had them for
I did it for you.
weeks, and whether
Just
that
for
was
you.
sufficient time to prepare on them, even if they're relevant. Well, what are the point? How could we be having all of these, new documents of high relevancy? Is there, can we narrow this if there's some, or is it easier to just say, we'll proceed, and if someone tenders an exhibit for admission, we can entertain any objections about timeliness or relevancy at that time? Maybe that's best, I don't know.
Your Honor, first of all, I want to go on the record.
Another
apologizing for my
Smith.
interruption you last year.
Thank you,
I very
thank
apologize,
you.
Mr. Friedman. I'm going to be working very diligently and not interrupting.
Appreciate
It's an
it.
issue of mine, so I apologize. Secondly, these issues, and these exhibits, I would love to have them tailored down because there is quite a bit, a lot of it is additional records I'm getting since that order that you've gotten, records I've been able to get and they kind of are trickling in, and quite a bit of it is actually correspondence and communications between myself, Mr. Friedman, and Mr. Perry and his now wife. So, or lack thereof.
Hey, Samson.
I don't mind. I've asked Mr. Friedman if he would stipulate, I'll stipulate to his. I've sent in the numbers. I said I would stipulate to his because I would rather kind of get this tailored down.
But he's not submitting new ones per se, like you, he's
Right, so,
resting
and
on
I
the
sent
ones.
him a letter and an email saying, I gave him this, I gave him what I was planning on, using. I've been very forthcoming, I gave him the exhibit, the index, saying, hey, can we stipulate any of this, is there, and I didn't get a response from him. Now he's saying today that he didn't like my tone, I don't mind, and I apologize.
Thank
I
you,
don't
Fletcher.
mean to cross-
What's the main gist? How could there be so much material?
I usually start 3 hours ago. 3 hours ago is when I usually start.
That we either didn't know about, that's really critical to this, but we didn't know about it and or couldn't obtain it earlier? What does this
I've
generally
disclosed-
consist of?
So I have disclosed everything to Mr. Friedman. I have disclosed everything. Unfortunately, by January 8th, I was not able to physically get all of them printed out into binders.
That wasn't really my question. Let's just
Okay.
assume all your efforts were reasonable and diligent in this regard. I'm saying,
Okay.
how are we have all these silver bullet panacea type documents that are so important that we either didn't know about earlier or couldn't obtain a few months ago? What's the main meat of what you've obtained that you think really needs to be considered and wasn't available or submitted earlier? What are these key documents?
I think the main meat is her medical records.
Okay.
Thank you,
and
Mel.
there's,
Thank you.
I'm not getting effective communication. In fact, there's been a significant regression in our
Okay, that's not,
communication.
okay,
So it's just like
we're
emails and letters.
that's two things at once.
Okay.
Medical records / verse,
That's one just of them.
unreasonable communication between the two of you. Those two don't coalesce, so let's keep this separate.
Okay,
Medical records,
there's,
why weren't they available earlier?
so some of them was able to obtain
Okay.
right away, so I've been getting, as I can obtain them, I've been diligent in working on getting them, and the second I get them, I do
Okay,
disclose them.
what do they
Some of these
mean,
were
what do they
from
mainly,
prior.
what do they mainly consist of and why are they critical?
The reason, well, one of my main points, is that Mr. Perry is in fact not, the reason why I think they're critical is one, just the recent conversation that we had about her surgery. That was in fact
Oh,
canceled.
by
It
the
was-
way, did you guys resolve that?
Well, it became to resolution, but not, this is what happened. Mrs. Perry, I don't know how you want me to refer to her now, his wife signed off.
How do you,
Carrie
would you like her,
Anderson.
just so we don't run into any issue with
It's my-
someone thinks
my
they're being
client's-
disrespected?
No, it's my client's
First
spouse.
name? Okay, how would you
My
like her?
client's wife, her name is Carrie. We
Refer
speak
to her
all
as
the
Carrie
time.
or,
We
Yeah.
don't speak all the time, but, okay.
pardon,
so-
doesn't matter whether you speak to her,
She's
or
the
Miss
one
O'Perry
actually
or
taking
whatever.
my daughter to these, medical, and so I wasn't able to.
The
obtain-
issue last time, I mean, I have zero tolerance for control stuff like,
No,
we
I know.
we don't like it because we don't like who's taking
No,
her there.
that's
The
not it at all.
question was, should this procedure occur or shouldn't it?
And it shouldn't have. The
Thank you,
doctor did
Fozzie,
say
and
that he
congratulations.
will on what happened, but
Did
in
you,
that
did you
medical
have a
record-
joint discussion with the three of
We
you?
did, but also Mr. Perry actually threatened to sue the doctor.
Okay,
that day,
let's
too.
say he
That's
threatened
part of
to,
it,
let's
for
say he
record.
threatened to sue the doctor, let's say he threatened to assassinate the doctor.
Okay.
We have to laser focus on the
Okay.
questions here. Did the two of you have a discussion with the dentist, or,
We did.
and whether reluctantly or not, agreed to the extraction or whatever the procedure was.
It was in fact, not, the doctor did not feel it was necessary at that time.
The
There's another-
extraction.
Yes,
So
and
what
going under
occurred,
general
a
anesthesia.
juvenile root canal or something? What occurred in place of the
It's
extraction?
going to happen April 10th, so
Well,
there's gonna be.
there is gonna be an
a caudicle
extraction.
put on to her on
Okay.
April 10th. But
So
she's
it
going
is
under
getting,
general
it is getting
anesthesia.
removed, the tooth.
It was being significantly drilled out and there was a steel cap being placed on
So it's
top.
like a juvenile
It's a
root
juvenile
canal sort
crown,
of, yeah,
is what it
like,
is.
yeah.
It's a teeth fall
So
down.
she figured that, she said that that was a little bit extreme, going under general anesthesia, and that there was another procedure that they can do in place of that. That's gonna,
What was the nature of that procedure?
we haven't had it, it's April 10th.
So they said, so I guess this answers my question, does this new procedure cause some delay? And I guess it did, right, because it's
Yes.
rescheduled April 10th. With reservations or otherwise, have you two agreed to this more safer, less intrusive procedure, and that this will occur April 10th?
I'll agree to do it, yes, a yes and a short answer.
Okay, and all this has to do with the information from the specialist. I don't care what you think of him or what he thinks of you, and you just, did the specialist think that this is best for her and that it should occur? So it's not, you see, it's not opinion-based. These things, unless a specialist or physician indicates, there is some room for a parent's input and decision and options, and sometimes they just say, hey, this is what needs to be done, and I'm not gonna waver on that just because parental pressure is being applied. So did the specialist indicate there is some degree of flexibility or options? Okay. And you two have selected this other option,
Yes,
and it's occurring April 10th.
yes.
And these people are not gonna be disrupted. Okay, now, I'm probably gonna regret asking this. Now, if there's, so, but I have to, because if this is agreed to, and I'm also hearing about this drama that he wants to sue the physician, what, is this in fact agreed to then if he threatened the person?
So.
It's a little hard to, well, first of all, a question answers itself. No, he did not threaten to sue the physician, or the physician would have said, I'm not performing this procedure on your child.
It's actually in the documents, it's on the record, so.
No physician, dentist, or anyone says, I will proceed with this procedure on this child, even though I've been threatened to be sued by one of the parents. Their malpractice carrier for one would be most aggrieved. And unless it was something immediate, life-threatening, like immediate, not like we can wait 4 days, but we can't even wait 4 hours, 4 minutes. You have to save this child now. There is no physician, specialist, or anyone in any medical field who would be that asinine.
No, she
That,
was not threatened. for the
Hi,
procedure.
Walter.
She's threatened to
Hello.
disclose information to me. She's threatened to be sued if she disclosed information to me.
I think that would be sufficient for them to say, take this young patient elsewhere.
Judge, I can maybe expedite things, since I'm
That's
not
what
prepared.
that's the addendum I wanna add.
Since we have not stipulated to anybody that's coming in, we've been offering.
What happened
My
with this,
attitude-
what happened with this procedure from your perspective?
What happened with the procedure is you had a medical provider who was faced with a conflict over the use or non-use of general anesthesia. I firmly believe it was a member
Hi, I haunt you if you're lurking. Hello.
of the doctor's staff who presumed, given the age of the child and the special needs, that a general anesthesia made sense. As I told Your Honor, I am not an expert, but I am a parent. And my own 8-year-old, who was then 6, had the same procedure done on 2 teeth. And he is not special needs, but he is a wildly active club wrestler with lots of energy. And they said, really uncomfortable going in and drilling his teeth that way. We'd like to use general anesthesia. And my wife and I may be barbarous parents, but we felt that given our child was in fact a very kinetic young boy, that a topical anesthetic would not necessarily do it. So when that was presented to Mr. Open Perry, outside of the defendant's presence, because she wasn't there at the time, with defendant, I think it was presented actually to Carrie. This is what we're gonna do. Carrie said, okay, medical provider's saying this is what we're gonna do. Sounds great, they scheduled it. We made Ms. Hurd aware of it. She was very, very, very concerned over the use of general anesthesia, as is her right. Your Honor.
And sometimes that's well placed in a
Fine,
child.
like I said, my wife and I may be barbarous parents for thinking that it was appropriate for our son to get it. But whatever the reality may be, at a point in time, the provider was faced with obviously the understanding that both parents were in the middle of litigation in court, that we had a parent asserting that this was a problem, and my understanding is that the position of the office was, well, given all of those factors, it does appear to me that we can probably try a least evasive method and use stoppable. And I'm assuming, Judge, if when they do that, the child is non-compliant and they're unable to proceed, they will stop the procedure and go, look.
The fact that
we
this
think
was
it's-
continued on supports what you're saying. They were not gonna touch this child. at
That is
time.
my sense of what occurred. What I was gonna say, just to streamline things, is rather than arguing,
If I had the option of knocking my kids out every once in a while, they should give that option to parents. You don't need dental work. It's fine. Just come in. We'll knock them out for a bit. That's all I wanted. That's all I wanted. Come here, honey. Does this smell like chloroform? But no, we don't have that option.
in
Did he
esoteric
threaten
fashion,
to sue the person if
to
this
my
is,
knowledge,
if it's
Judge,
relevant?
I agree. I don't think it's relevant, to my knowledge, no,
It's
and to my
probably
knowledge,
not,
it would
but
be,
maybe,
it would be inconsistent with continuing care. I
Right.
agree with you. Just like an attorney, a dentist, a doctor, somebody comes and says, I'm gonna sue you, you don't
Right.
say, well, tell you what, let's go ahead and head to trial
Right,
tomorrow.
exactly.
Right, you say, well, I can't do anything. So, but I would say, rather than having a debate in the abstract about whether something was disclosed, and if it's late disclosure, or putting a trial exhibit on day 5 into a trial binder, which may never be offered.
I mean, we
Why
are,
Gonna
but
wait till an
don't we
individual
just take them
document.
as they come?
he doesn't have to say it like that.
Well, that was what
There's
the
an
court
issue, there's an
indicated at the beginning, that that's probably by default the preferable method. Because, yes, we don't want to spend a lot of time about arguing about 98 or even 99.9% of material that isn't offered isn't important. It's best to wait until, to see if a few of them are offered, then entertain an objection about when the disclosure occurred, how relevant they are, et cetera. Because, unless you feel that there's some review that's occurred. Do you have any knowledge of documents that have been supplemented, whether medical records or otherwise, that might be important or useful?
I think I told Your Honor when this was broached at the hearing, you were generous enough to hold during the middle of the trial because I was ill, and I appreciate Your Honor doing that. I know you have litigants in the court. So when it was addressed then, Your Honor said something to me sort of off the cuff about, well, Mr. Friedman, if it's just a complete set of medical records, are we really gonna have an
Correct.
argument? And I said, Judge, if it's just COR certificated medical records showing a complete medical file, the fact that I got them on day 5 of trial versus, when I was supposed to, yes, it's technically a procedural fault, but I'm not going to stop a whole trial and grind it to its halt over that issue, right? But my understanding is, what I'm looking at extends well beyond all of that. And what I tried to explain to Ms. Hurd when she would present these to me, and so just so you know how I would get them, I would get emails in the context of sort of her demands for other things and being frustrated that she wasn't getting exactly what she wanted, and then I would get consider this my formal disclosure of all these things. And after receiving several of them, I said, Ms. Hurd, I just need to explain to you that I understand how tenderhearted these proceedings are, but as a pro se litigant, she said, I'm entitled to the same rights, duties as any represented litigant. I said, you are.
And also the
Absolutely, but
same
you're also,
responsibilities.
the same exact duties and responsibilities apply, meaning the rules of civil procedure, the judicial court rules, Nevada Supreme Court law, and Nevada statute all apply to you. And they apply just the same way as they apply to me. And I said, so there are 2 sets of rules, regardless of how important the legal issue is to you, and no doubt this is to her. And I don't know that she loved that response, and she basically told me I was wrong, and I said, well, I'm not gonna continue to debate this with you. So that's where we are, Judge. As I said, I'm more than happy to, throughout, Ms. Hurd's
Me too.
presentation, what I would, let her introduce these exhibits if she believes she's going to introduce any of her exhibits or the additional exhibits she's provided. I'll certainly look at the exhibit when it's offered. If there's evidentiary objections to it, or procedural objections to it, I can raise them, Your Honor can rule it, and we can move forward. We don't have to waste sort of time in the abstract. The one housekeeping matter I would say, Judge, is that Ms. Anderson, we told Your Honor this the last time we broke at the end of session 4. I do know that was a setting that
I feel like starting a consulting firm, but a different. Like, CJ is a professional. CJ cares about people's feelings and tries to help them see things the way they should see them instead of the way they do see them. My consulting firm would be way different. I would do a lot of swearing. I would do a lot of truth telling. And people would come in and they would hear what they need to hear. They wouldn't like it. They would get mad. They would probably sue me. But I should not only open this, but I should charge like $1,000 a visit. And I'm going to tell you exactly who's right and exactly who's wrong. And I'm going to tell you if you're being stupid. And I'm gonna lay it all out on the line. I think it'll go off big. I mean, people pay to go to those restaurants where they swear at you and are really rude to you. Karen Steiner. I think they would pay for the same type of consultant. Oh, marriage counselor. Yes. Speaking of marriage counselor, I will take $100 donations if you want me to be your marriage counselor and you want me to always only be on your side and tell your significant other how wrong they are every visit. So I can pretend to be a great marriage counselor. I can use big words. $100 a visit. I'll make sure that you look good every single one. This can't go wrong. This will work.
And the defendant was 04, which we moved, and then myself. So we all may have a little attenuated memory.
No, CJ, I don't like that person.
That we were going to have Ms. Anderson present for the very next day, and that the thought was that if we were going to be calling her, we would be calling her then. She is present here today. Carrie is present here today. And she is not going to be able to be present on Friday. So what I would suggest is, I know the defendant was adamant when we closed at the end of day 4 that she intended to call Ms. Anderson. Is that correct?
I do intend to call her, but I had also discussed with you, that I wanted to recall your client, or finish with Mr. Oak.
Was he, so I don't have to dig through the rec, it's been on, was he was remaining on the stand when we.
We had truncated his testimony. He had stopped, and I believe we had, am I incorrect? I thought we had stopped his
So
testimony.
you were directing him?
No,
You
it was,
We stopped him and then we did his.
we went on to his mom, no, not his
Yeah,
mom.
who called him technically, whose case in chief?
She
was it?
called him. My recollection was, and forgive me, Judge, I will have the notes for it if you want.
So where did it leave
We're trying to log
off?
on to the internet.
Who was
My
questioning
understanding
him?
is that we had stopped his testimony and truncated it because Your Honor desired to get other witnesses who were present on.
Okay, and he was gonna then,
And then you were gonna have him retake the stand and can answer redirect. Well, all I'm saying is
she would be, well, I
finishing-
guess technically her direct would have sort of crossed because it's an adverse, but
Whatever.
she would, right, she would be recalling him. He would be continuing.
The only issue would be that we can't, Ms. Anderson is not able
Okay,
to be here on Friday, and what we had said to Your Honor, and you were actually said to us, I think, you were not interested in letting it go, so your intention was to have this wrap in the full day setting we had. I understand now we have 2
Right.
half days, but that we weren't gonna just let this go on endlessly, and so my thought is if she thinks she can, go to Mr. Perry for some bit of questioning, and then complete her examination and allow for, my redirect, recross, whatever you wanna call it, Ms. Anderson, then fine. Otherwise, I would say let's at least start with Ms. Anderson, so that if we truncate Mr. Opapari, he's gonna be here, Dave.
okay, so when Miss Anderson's done, she would be continuing
With
with him?
Mario.
Okay, he was still on the stand through her case and she,
That's correct.
Just according to
Mr.
my notes.
Opapari, because I continually say Pari and I'm incorrect.
and the offer of proof again about Miss Anderson?
Oh, I didn't know she formally changed her name. For the record, she has formally changed her name. They are married, but
Oh.
the name change is also in process. It is Opapari as well. So Carrie Opapari and Mario Opapari.
And
Carrie
the nature of the
Opapari.
testimony, Pretty obvious. but for the
She
record,
picked
it's
that.
offer of proof of the main. just the
Dear,
Miss
why don't you take my name this time?
Offer for the defendant. Either
Well,
way, I would just be,
Who's gonna commence with the witness?
well,
Oh,
my understanding is that she wanted to call her.
right.
I
What was the main point you were hoping to offer proof of what you're hoping to establish with the witness?
Well, I guess the main point is that, that she's trying to replace me, and in fact has.
No, I don't, what I want, we have to be really precise. Are you arguing that, which you can wait till later, or are you saying that's what you're gonna focus on, with one of the things you're gonna focus on with this witness?
That's one of the things I'm
Okay,
gonna
okay,
focus on
okay.
with her.
What else
I-
are you gonna, what else are the main topics? And this is an offer of proof for any witness he calls, you can say, I'd like an offer of proof as to the main meat of what their intended testimony. So that's all this is, I wanna get an idea of what the purpose is, so that if this testimony is helpful to you, I'm able to focus on what you want the court to focus on. So what's the main point you hope to accomplish with this?
The main point is, I guess the main point is what I just spoke right there.
That she's
There is a lack
interfering?
of communication, and that she's trying to, in fact, just replace me as a minor child's mother, and there is no effective communication. So I wanted to focus on some of the medical records that, in fact, she is taking the minor child. There's been some recent issues that she's shown up to medical appointments, and I'm still being verbally assaulted by the secretary.
And certainly anything like that, if it's established, is of significant
And one
concern.
thing I also want to, I guess, talk to both of them about is that I didn't get to have her for Easter this
Fair enough.
year.
I mean, things about disrespect and all that can be developed. As far as that other issue about quote-unquote replacement, sometimes it's a matter of a degree. Sometimes a step-parent, particularly in litigation, it's a lose-lose situation. If they try and be proactive, responsible, and loving for a child and make appointments and fill in when their spouse can't, they get accused of the other parent of trying to replace them. If they're hands-off, then they get accused of being a neglectful, non-conscientious step-parent when there's a special needs child. So sometimes, I'm not saying this applies to her, but I'm saying this is a common situation, and if no one has a right to be abusive or belittling to you, and if you can establish that, that's of significance. But if someone is taking a child to an appointment, and we get this long debate about, well, I had to, because the other parent wouldn't, and then, oh, no, yes, I would, and you didn't let me, and you just did it, then I have to interrupt it and say, is any of this established with emails or text messages to whether the other parent was cooperative or not? So is it just gonna be on her attitude, or are you gonna be upset at her participating in certain health or educational matters, which by itself you kind of want her to be involved?
If she
I mean-
was doing what was best for my
Okay.
child, absolutely, but that's not what's happening
What
here.
what is she neglecting or doing wrong?
Well, primarily is the lack of toileting.
Okay.
And that was an issue. And also her actually actively, while we're in a trial, I wasn't allowed to go with her to the emergency room, even though I was available. And she went in and represented herself as being my child's mother. My child has a mother, it's me. And
Thank you,
I'm not
another
fighting
Smith.
for
Thank
custody
you.
of Mr. Perry. I'm in fact fighting against Miss Anderson. And I don't have a problem with the step parent. My son is 30 years old. He doesn't have a stepmom. He has another mother. And we worked hard for that relationship. I'm not getting communicated to. Just today, just out here, I said hello to both of them, and I got completely ignored. I am
They're probably
trying,
playing it safe, because if they
I
said,
get it, but I'm also
in my
asking-
opinion, if they had said anything, I would have had to hear about it for 10 minutes. They would have said it's distorted and
I know.
misinterpreted.
And I just-
You would have said, no, it wasn't, it was vicious and belittling. That is a
OMG. Another Smith. I don't know how you did it. You must be magic. You got Sue. Sue is so hard to get. And you got Sue. How did you do that? We need to know how you did that so that we can do it again. You got Kit Kat too. Good job. Well done.
fact. That's what would have occurred. That's not what may have occurred, that is what would have occurred.
There's a lack of communication.
Okay.
There's a lack of communication between me and Mr. Perry. I'm asking every Wednesday and Thursday, which I have not been allowed any.
You got Kay. Ah.
Not in for spring break. I've asked for overnights. I'm
Well,
not
that doesn't
allowed.
have a lot to do with her. He's the
But,
gatekeeper of
so I'm
that.
getting, so this is the thing.
Sue.
Her and I, there's not an established relationship there, and okay, so I had to exchange with her this past week. I went and sent a text message to her, can I get a potty report, and I get ignored. My daughter she started wearing panties yesterday at school by her IP because of
Could
the
it be that
conversation.
whatever she presents is gonna be, she may be afraid whatever she presents is gonna be not just criticized, but harshly criticized? How dare you replace your judgment and medical judgment for this? Maybe she is lacking in these areas you're indicating. I'm just painting with more broad strokes. Generally speaking, when these themes are developed, it turns out that the parent was prudent, the step-parent was prudent in not responding to all this. And most step-parents, if they're in a case of this sort, would probably be advised to provide, to have the the actual client, the father, provide information that's being requested, which the mother doesn't have, or vice versa. But to not suck in not let the step-parent respond, because it will not allay someone else's, the other side's concerns. It'll just exacerbate it. It'll be, how dare you, you're not the mother.
I don't feel that way.
It would happen. It would happen. And you need to have the personal insight to know that there is so much baggage here that I think, and as most parents, in this situation, you can't prejudge something. Don't be, I have a feeling in this case, kind of both sides are ready to attack the messenger instead of looking at the content, medical or educational. It's kind of, how dare he or she tell me what to do, or I don't approve. I think you're both sort of conditioned to just reject what the other is suggesting out of hand, and that's been made crushingly obvious in this case. I think to a large extent, you're both sort of hardwired to, here's a communication, I haven't read it yet, I gotta be ready to attack and contradict,
Lori,
etc.
thank you.
I don't think either of you, at least that this is the point of the evidence now, and it's up to you guys to change the court's perspective. I think you guys look at a communication and say, oh, like you wince and you dread it when it's coming in from the other side, and you expect to find fault in things you can both contradict. I don't think either of you have ever picked up in the last few years, received a piece of communication from the other side and said, oh, hopefully we're going to make some progress here. And when someone contradicts that, they say, oh no, I was hoping for positive progress, but progress defined as it has to be all my way or him all his way. I mean, and I've read these communications, and if you guys have more along the same line, that's fine. But I guess since it's inevitable that, guess maybe, unless you've something else to offer about what she'll say, I guess rather than just delaying it, why don't we, you want to bring her in, or is there something else you'd like to say about any of it?
Can I say something real quick, Your Honor?
Pardon?
Can I say something real quick?
Yeah.
Can you give me 5 minutes to talk with Mr. Friedman? Would you be open to that?
Okay. If it's productive,
Judge, I just,
you can take a heck of a lot more than 5 minutes if you get anywhere.
I doubt very seriously it's gonna be summative, but if it is, I would love to have that conversation. You just want to emphasize that the amount of time of this court, and I appreciate your patience, but it's also costing.
I'm not sure I'm exhibiting a lot of patience in this case,
I mean that we've had so many days, Judge, and my
I
concern is that
understand.
we're gonna get to a point where Ms. Heard's going to tell Your Honor she needs more time.
If you
Yeah.
don't agree, then we'll.
Okay.
Okay.
And anything you guys, whenever you
fine.
guys discuss something.
You understand, Judge, I just don't want to be
you
to the
know,
point where a Friday end of day and it would
Right,
be
exactly.
3 more days.
And when you guys discuss these things, it never helps to look at the end game. I want this title, I want that title. It should
You
be
do not have to.
looking at the weekly schedule, what would make more sense, what would be more fair. And if people agree on a weekly
Bye,
schedule,
Maiko.
it's amazing how all those other things fall into place. So work backward that.
It's all right, Maiko. It's
If you
over.
guys can stay here and
Okay,
keep the room,
thank you.
I'm good. Appreciate the,
Oops.
part of your
It's all right.
assurance.
I'll fix it tomorrow. Whew. Okay. We have one more day. One more day. We're going to finish this tomorrow. And then it'll be over. And then Beck is going to send us a link for the next one. Beck, find a good one. Yes, Mel, we've been at it for a while. We got to stop. There has to be a stopping point. No OJ today because I work a double. So I shall see you all, maybe. I don't know what tonight is going to bring. I don't know if we're going to get customers or we're not. And I don't even know if Bill's going to stream. But what I'm hoping for, my goal is that I get off work in enough time to see you all in Bill's stream. I hope I do. All right, guys. Thank you so much. I'll see you as soon as I can. Be good. Bye.
She's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no